is that cat?
Archer. You just gonna stare at me? Oh.
I am walrus. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Welcome to a very, very special episode. It is 11 o'clock and 11:30 in the morning, which is a very surprising time for me to go live. But you know, I got the day off, so I figured why not. We're gonna take a look at some courtroom videos from old Squishy Gardener, featuring a more that we've seen before. But also we're going to start with a case that I hadn't seen yet, but it features probably one of my favorite judges. You know, I love Judge Middleton, but I love this judge too, because she lays the smackdown on sovereign citizens really well. So we're going to take a look at these videos. Might keep on going before. Might keep on going. But yeah, so I don't know. I don't think there's going to be a stream tonight. I might actually touch grass and go out and meet with people. So this will be my this probably will be my stream for the day. All right. But oh well, just to give you guys a bit of an update, Archer's all right. He's being a brat though. He's not eating. He's drinking water, but he's not eating a whole lot. And I think the main reason why is because his regimen is wet food for the next couple of weeks. And I've always usually given him and Winston dry food in the mornings before leaving for work, and then wet food in the evening. So he just may not be used to it. But, you know, doctor's orders and all that. Anyway, he's doing well, notwithstanding. So we're gonna take a look at these videos. All right, let me push this to the appropriate one. There we go. Let's get the show on the road. It's Judge Lenny's Bryant. So she's a legend. I love her. Uh-oh. No audio? There should be audio. I'm hearing it. Don't tell me it did doing this thing again. Mm-hmm. Oh. Let me turn this off. Uh-oh. Try this again. Okay. Nope. Still not working. Why? It was working earlier. I know I've had this issue before, but why now? And I completely forgot how to fix it. Sorry, I'm just not in the mood for people making fun today, but it's okay. It was running fine earlier. That should be working fine. Yeah. Give me a second. I know it's a black screen. I turned off. I closed the picture. Hold on. All right, I'm pissed off. All right, why all of a sudden is my audio not getting through? The last thing I need is uh-oh. Wait, is this it? Does this fix it? No. Doesn't fix it. Okay, I see that what's happening here is where's the throughput happening here? The volume mixer should be that. Okay, so it doesn't seem like nothing is going into my headphones. So why is that happening? I don't know why it's well, this is just par for the course for my life right now. Huh. I don't get it. I don't know why you guys can hear my mic, but nothing. Like, I don't understand why. Oh. It's just, this is embarrassing, and just, I don't get it. I don't understand. I don't understand. It's pissing me off. And I'm getting really stressed out. This is like the last thing I need in my life right now is just be completely embarrassed.
Trump told the individuals that the plan was highly confidential.
No, but that's the desktop audio. That's not what I want. Why is it suddenly... I already have checked the volume mixer. Is that it? Is that what fixed it? I think that's what fixed it. All right. All right, I fixed it.
Defendant is
All right. I'm so sorry, everybody. Just par for the course.
charged with one count of assault or assault and battery. Today is the date set for pre-trial conference. And Mr. McCreary, your name?
Ernell Michael McQuarrie Hill, all lowercase. Not
And now everybody, and now people are saying it's a fucking echo. It is, of course. Fuck me, man.
And if you deny that, it then goes to the chief judge.
He already
Well,
did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion.
correct.
He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request.
Storms are brewing out here.
I will sign an order denying your
That's the
request
second time I heard thunder.
and then forward that to the chief. Okay?
Well, how do you say who do my call? The clerk? What is not?
Sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal.
Yeah, we're not surprised that she's going to deny his request for recusal. I kind of wish we knew like more of the background.
Oh, well, what else is there, Mr. McQuarrie?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr.
this
McQuarrie,
is a
I don't
court,
take
man.
things personally. Ms. McQuarrie, let me say something to you. So since we talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And
Correct.
maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However,
what is... Okay, now I really want to know what's going on. How in the world are they still dealing with a case that's 21 years old?
However, we're going to proceed in the manner that you wish to proceed. And so I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man,
This has nothing to do with
Oh no.
the defendant in this courtroom.
Oh no.
For the record, is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the
feds, I guess.
Parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McCreary is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right,
May I
then, sir,
re-
you're all set. You have a great day and you stay safe.
Oh, yeah.
Not as spicy as I expected it to be, but I always appreciate Lanice Bryant laying down the law against them. So this one, we have actually this character we've done again. We've oh my gosh, we've encountered before. We talked about before. This guy with the fez. Hey, whoa, hey, Kojak, thank you for the 10 gifted memberships. Really appreciate it, man. And Akira, thank you for the 26 months. And Kojak, again, thank you for the 30 months of support. Really appreciate you guys.
Morning, Ron. Yeah.
Good morning, everyone.
Good morning.
Are you ready on the motion for Michael? Is it McCreary?
Yep.
All right, the clerk can call the case.
2356485, the people of the state of Michigan versus Carnell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to rape, violent, harm, less than murder, or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8.
That's right. This I forgot. This particular Moore is facing some serious charges. This ain't no traffic offense.
9 and 10, weapons, felony, firearm, with a habitual offender fourth offense notice set for a preliminary examination today. Before the exam, there was a motion that was filed by Mr. McCreary to disqualify me from this case, and that is why Chief Judge Conoco is on Zoom to address that motion.
Okay, appearances.
Edwin Sawaki, P54A28, appearing on behalf of the people.
Ernell Michael McCreary, natural person, not a corporation. Natural.
Is he off screen?
Okay, thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Elias Sabri pursuant to MCR 2.003. The court, having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabri, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabri is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case. So the motion is denied.
Well,
Thank
there
you
it
very
is.
much.
And Attorney Washington, I know you want to put your appearance.
Oh, yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak?
So this is the chief judge is speaking here, but the other judge is on the bench right now. For those who aren't aware or didn't who don't remember the last stream that we did with this particular Moore, he's not facing a mere traffic ticket. He's facing serious charges: attempted murder, attempted SA, which is all the more reason why he needs to drop this BS. Like, just like with Brooks, that you're facing serious time and serious prison time. Why you would entertain this is beyond me, but I mean, it is what it is.
Judge.
That matter.
Now that matter is resolved now. The court is turning over back to, excuse me, sir. The motion is the motion was denied, and now the court is being turned back over to Judge Sabri to handle the preliminary examination. Thank you very much.
Well, can I at least place my objections on the record?
It's been noted.
I mean, I'm just saying
Mr.
because
McCreary,
I
your
thought you were the
objection,
chief.
Mr. McCreary, your objection has been noted.
May I address the court?
Not on that matter. I can't hear a motion to disqualify. According to Michigan Court Rule 2.003, the chief judge has to address it in a
But that's not how the rule is.
multiple judge court. This is a multiple judge court. Chief Judge Bucanico just addressed it. You received your motion in writing and he responded on the record and he denied it. There could be no more discussion from me about the disqualification motion, Mr. McCreary. It's been denied.
But can I just address something? I mean,
It's already been addressed in your pleadings and I cannot respond. I don't know if you
That's not
understand.
what I'm
I
trying-
can't
that's not what I'm
respond
trying to do.
regarding the disqualification.
I'm not trying to do that, Your Honor. What I was saying per the rule,
Well,
due process.
You're still
You
talking.
were-
That's right. He's not. This one is not more. Well, this particular the subset, he's not a more, but but the title says that he's going to go against a Moorish subset. Interesting.
Yes. And I
Which is actually one of the reasons why I think this is interesting, because I do try my best to kind of tell people to differentiate between Moorish sovereign citizens and other sovereign citizens, because they all have a very different, alternative history to go on. And some of the lingo that they use and some of the bases for which they make their arguments are different from each other. And also to note that not all Black sovereign citizens are more sovereign citizens.
I noted that. So as far as the exam, the time is now 10:17. Are you ready to move forward with your preliminary examination?
I came here today with intent, like.
Yes or no?
No, I'm not prepared because of this. I mean, I would like, you won't let me.
Hey, Gogeta, thank you for the 8 months.
To respond, but you won't give me a fair chance to say or speak.
Mr.
I mean,
McCreary,
this
I
is-
let you stand here for 45 minutes last time we were here talking to you, didn't have anything else to say. So today I'm asking you, are you ready to move forward with your exam?
No, I'm not. I would like to call
Based-
witnesses. and
Based on
subpoena.
what?
Pardon?
Based on what?
Because my intent as today, this motion was filed, the court was supposed to deny it because I thought you were the chief judge pro tem. And per the motion, it says that if you were the chief judge pro tem, it was supposed to go to the state court administrator. This gentleman here, I'm not familiar. Like first, the
You're
way the
still
rule-
addressing the motion to disqualify.
my due process is being
And
violated, Judge.
it's not.
I mean,
Because if
you won't let me
read-
tell you
It seems
why.
as if you can read it right. The court rules are very clear about motion to disqualify. There's no it's black and white.
But,
So, Mr. McCreary has been denied.
okay, we
And
understand
if you
that.
knew that, it also says that there's a timing in which the court can address that, can be any time. So you knew you need to move forward with your exam today.
Well, what I'm saying is
So-
I have a right under 6.110
So-
to call witnesses,
Yes, you
things of that
do.
nature.
And why aren't you prepared today?
Because you won't let me speak.
I
Your
didn't,
Honor.
no, I said, why aren't you
I'm trying
prepared
to,
today?
I'm trying to tell you.
Today's your exam date.
Can I respond? You keep cutting me off, Judge.
You're not answering my question.
I'm not prepared because when I filed this court was supposed to make a ruling. Then if you denied it, it was supposed to go to the chief judge.
No,
That is
I
the
can
process.
tell you no. It's not.
That's why I'm not
I can't deny a motion to disqualify in a multiple judge
Yeah.
court.
Can I pull up?
Well, I mean, I say yeah, but I actually don't know the rules of court in Michigan. Some jurisdictions, like what this guy is probably confused about, some jurisdictions, and I imagine maybe in other, she says it's a multi-judge court, the trial judge will initially respond to the motion to disqualify, but then I think it's like an automatic review by a judge higher. But obviously, as we know with the Blandino saga in Nevada, the judge against whom the motion to disqualify is being filed against doesn't make an initial ruling. It automatically goes up to the next. It's automatically reviewed by a separate judge.
Rules,
Can I-
2.003.
I'm familiar with it very well.
We're not that
In
familiar.
Crampton versus Michigan Department of State,
You
said
can
even if
say
you
any
can't
case
show
law you
bias.
want in a multiple judge court. I cannot handle your motion that you filed. It goes to the chief judge. Chief judge, I am chief judge pro tem, two different things. I cannot handle my own motion to disqualify. That would be bias, Mr. McCreary. So do you have witnesses subpoenaed?
You won't let me respond.
Yes or
Judge.
no?
No, I don't.
Okay.
Because my intentions, as I stated, under
It's
this
just a
rule.
yes or no. I just want to know.
I
So you
mean,
can finish looking under court rule 2.0.
why am I not being allowed to address the court and give it a fair exchange like
I'm
the
asking you
prosecutor's office?
questions. This is not your courtroom. I'm
I'm
asking
not
you.
trying to
I
disrespect
have
this court.
given you all the leeway up until this point.
I mean,
He has.
Today's the
right.
exam day. Go ahead and check your court rules. Get back to me. Are the people ready to proceed?
People are ready to proceed, Your Honor.
And I object, I'm not ready. Because, I mean, I would like to address the record for preservation rights. So far as I have to go to the
Do you
higher
want to
court.
research 2.003 first? Because that seems to be what you were stuck on. Maybe I want you to go ahead and
I
find
mean,
that
there's
first.
Michigan case laws, but
That's Court rule 2.003. Go ahead and find it. Tell me where it says that I'm supposed to address it.
okay, section B, who may raise, the party may raise the issue of a judge's disqualification by motion, or the judge may raise it, B, disqualification of judge is warranted for reasons that include but are not limited to the following. The judge is biased or prejudiced for or against a party or an attorney. B, the judge based on an objective and
Those are the
reasonable.
grounds. You gotta get to procedure. Section B.
Oh, my goodness.
I can read it for you. 2.003 D3 under ruling.
I mean, I was getting down here.
One, in
You
a
say
court having
B3?
2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge, who shall decide the motion to no.
Okay. That seems pretty cut and dry to me, but
So, Mr. McCreary, I am ready to move forward with the people's witnesses.
Well, I have evidence, I mean, since you're forced to compel it, which violates my rights under UCC 1-3. Wait, also, I'd like to.
oh my god, UCC.
Again, motion to challenge the jurisdiction of the court. After this, the hearing we had last, I believe it was third, no.
And challenging jurisdiction.
30th, I believe it was. The prosecutor gave me 15 pages, and he attested on the record, this 15 pages all they had. There's no warning, there's no signature signing off for the prosecutor to initiate charges, whatever else. I mean, this whole case, I object to this case being moved forward under Brady violation, Fourth Amendment violation. I mean, they're committing crimes here in this courtroom, and this judge, you're allowing this.
Nothing has been presented to me.
I mean, I'm just saying.
I'm talking. Stop talking over me. You've been doing this since you've been in this courtroom. Every time you talk, I let you finish, whether it means it's meritless or not. I haven't heard anything of any substance or any value worth me addressing when it comes to Brady violations. So I'm ready to move forward. And if you want to call witnesses, and we have to hold in part because you didn't subpoena them today, we'll address that when it comes time after the people rest. So, Attorney Washington, is there anything you'd like to put on the record?
Always lawful, Brian.
No.
Okay. Any preliminary matters from either side regarding the exam?
Preliminary matters, yes.
People will have to address the court first.
Yes, Your Honor. People have exhibit 1, which I will show to the defendant and his Mr. Washington here. It is a register of action certified, case number 98007-861-01-FH. It indicates that defendant, Mr. McCreary,
Hey, Jassa, thank you for the 10 months.
pled no contendere, assault with intent to maim, related to people with exhibit 1.
Oh, you say, I was found guilty. Assault with intent to maim. Hold on, he said I was convicted of that?
Under what court, under what statute?
Oh, I'm sorry, Your Honor.
I object, I wasn't convicted.
MCL 766 11B 1B.
Okay, so he's so the state was mentioning that he was previously convicted of assault with intent to maim. He's disputing that, but I think he said that he pled nolo contendere, which is, no contest. But it's effectively in actuality, it's like a kind of effectively a guilty plea. like in practice. But I guess that's why he's disputing this.
Back to that, Judge, I was not convicted of that. Matter of fact, Judge Darnay Robeson was a visiting court. And again, this gentleman is lying to the court. He just lied to the court. That's perfect.
And you had the opportunity to review the document?
Well, he said that I was convicted of assault with intent to maim. Can I ask that what you said?
I said, you pled no.
No. I wasn't found.
Mr. McCree, you review the document first.
Yeah. Okay, well, what does this got to do with the case? Robbery not armed, and assault with intent to maim. I have the transcripts at home. And the court order from Judge, he was a visiting Judge Darnay Robeson. Matter of fact, in that case, Your Honor, the prosecutor, what was this, Thomas Beadle, I believe his name was, he said that the officer in this case lost his entire file.
Can I see the?
And I have this transcript at home. How you gonna speak on someone you lost a file? This case was the felonies was. It was a misdemeanor, aggravated assault. And that's the case that, because in the transcript that I have at home, I would like to make that in evidence after this is concluded or whenever I can. Because he's just lied to this court, Your Honor. That's perjury committed in court, Your Honor.
Okay, I have a seal here from the register of action sealed from the Wayne County Clerk's office stating that you pled no contest to
That's inaccurate.
assault with intent to maim.
That's inaccurate, Your Honor. I had a transcript at home.
Can you let me finish what I have to say, please? Sentenced and committed to Wayne County Jail.
Mm-hmm.
Sentencing on September 8th, 2000. So for exam purposes under MCL 766.11B1B, exam purposes only. This satisfies with you can place your objection on the record.
Well, I would like to say, because in this case, I have the transcripts at home. And I object because this man just lied to the court.
If you have transcripts of this sentencing hearing from this prior charge, why didn't you bring them with you?
Because in this case, Thomas Beadle was supposed to be the special prosecutor. They held me there for 2 years. Then he stated on the record there's no support for this case. The officer in charge lost the entire file. So how are you going to present a register of actions? That's not evidence, Your Honor. I have the evidence at home. And
then why did you bring it?
I would ask that you hold him in contempt of court for committing perjury.
I'm gonna hold you in contempt of court in a minute. You keep talking over me.
Yes, finally. I honestly, I kind of agree with OSG. The judge, taking both hearings into consideration that we've watched, this judge has given him so much leniency so far. But she needs to start hammering him down.
I'm going to admit as Exhibit 1 over the objection of defense as a certified copy from the clerk's office for exam purposes only, showing that Mr. McCree was convicted of felon intent to maim in 2000. Anything else for preliminary matters?
Not from the people, Your Honor.
Okay.
Also, Judge, I would like to make a motion to sequester because my intention is to call the chief detective on the stand because.
Okay. You don't have to tell me a theory. I will do it.
Okay.
So let me do that first. So if there's any potential witnesses on this case, now's your time to log off. As far as in the courtroom, if there's anyone present who may testify on this case, maybe a witness, now's your time to exit the courtroom. What's next?
Per the court rule, I'm allowed to admit evidence for evidentiary purpose of impeachment on people versus Stanaway. I also would like to address to the court, Kim Worthy, last year, put a witness list out for officers who have previously testified falsely in court proceedings that they couldn't testify in future proceedings. My brother, Norman McCreary, has committed perjury in front of Chief Judge, Wayne County Chief Judge Freddie G. Burton. He committed forgery as well as identity theft. Also, I have affidavits from my other brothers where they've been trying to press charges. I tried to press charges. And the prosecutor them not doing anything. Also,
can I address that first?
Yes.
So
The reason why the detective's being sequestered is not so that he can't testify. The premise behind it is so that witnesses, because it sounds like there's going to be multiple witnesses that are going to be on the stand, and the point of sequestering is to avoid the the possibility of witnesses changing their testimony based on the statements of other witnesses.
Mr. McCray, if your brother testifies, you can definitely cross-examine him, impeach him, and bring all of that out. And if the prosecutor objects, we'll address it then. But you can do that on
I need to get y'all copies.
No, I don't receive copies until you introduce it and it's provided to the court. I don't do any preliminary impeachment. So once you cross him, if it comes out that he was convicted of a certain crime under the court rules or under evidence that allows you to discuss it, then that's your right to do so. Next.
I would just like, he was not convicted, but he was in the courtroom that was established by the Chief Judge Freddie G. Burton. And my other brothers were kept in the Bryant all these years, and they're trying to come forward. And I have an affidavit on my phone from my brother that's notarized. He's in the state of Florida. And
the brother that's testifying
no,
today?
my brother Charles was at 5-0.
So you have to address your brother today when you cross-examine, okay?
Also, again, I would like to renew my motion to have the prosecutor's office withdraw.
Tones, what's up, man? I'm noticing a pattern with people having misconception that a prosecutor will file charges on somebody solely because you asked them to. True. I mean, never mind when a regular citizen who is trying to forward charges to a prosecutor. Prosecutor sometimes doesn't file charges based on what the police give them. So that's the essence of prosecutorial discretion.
Wrong because of criminal misconduct, conflict of interest. My former attorney works for Kim Worthy as the director of the wrongful convictions unit, Valerie Newman, and it is quite well documented that Kim Worthy, as well as my former attorney, committed felonies, and it's all a matter of public record. And you know, for this gentleman here to come here and try to mislead the court, I believe it's under rules of professional conduct. It states once an attorney knows. I believe it is.
Actually, I'm gonna pause because I want to see the rest of this. So I'm gonna pause right quick. I'll be right back. All right, we're back.
They have told the court something, they must correct it. And this prosecutor is committing misconduct because I have from a stenographer transcript at home, in which I would like to.
You know the avenue to do that. If you want to report misconduct, you already know that. So let's get started with the exam. I've heard all of your motions and you place it on the record, and you will of course order the transcript to be able to move forward to the next step that you want to do. So any other preliminary matters to address regarding the exam today?
Well, how about, I'm just saying this, the recusal aspect.
I'm going to deny that.
Well, can I place my objection?
Absolutely. I hear your objection. Everyone else does. Ready to file your first witness?
Yes, I am, Your Honor.
Mr. McCurry, do you want to sit at the table up here?
I would ask that the police officer be called first because we have to establish how he investigated and other things that nature.
Now that would be you working for the prosecutor's office. You
Pardon?
don't get to tell them how to try their case.
No, I'm not saying that. What I'm saying is I want to question that investigation.
Okay. And if
Finally makes his appearance.
address that request or call who you said you're gonna call.
I have one witness.
Okay. So in this case, you get to
Well,
start with
can I
how he
call
wants to.
as a witness? Being that he's trying to bring my brother, I would like to
So
establish.
procedurally, prosecutor has the burden of proof. You should know that. So
Well,
they have to go first. They have the burden here.
well, they have no
And then
evidence,
you
Your
can
Honor.
call
further.
witnesses if you like to. If
Yes.
you feel necessary, you can do that. We'll discuss that after the legal rest, okay?
Yeah, they have no evidence, Judge.
You don't know what they have.
They just said it's in the paperwork.
I would like you to stay focused, okay? And the first thing we're gonna do is hear testimony from the people's first witness. That they have a record. So please, call your.
People call Norman McCrary.
So here's his brother.
Record, please.
Norman Leon McCrary.
And what brings you to court today?
The incident that happened on the 9th, and I was leaving the house after another incident that happened inside of the house,
Okay,
and I went to my next door neighbors.
okay. Let me back you up a little bit. Was that February 9th this year?
Yes.
Yes, and did that,
Objection leading.
Piece of paper?
No, I have some. Objection, he's leading the witness, Your Honor,
I think, sorry, go ahead.
because he said no.
It is
one witness testified
I mean, technically it is leading, but God, it's such a weak sauce.
that it was night, I was merely, clearing up the accident of which, that's in the county.
Yes, ma'am.
Because all the CEOs work together. Now, you had confrontation, right?
Yes, if that's what you want to, yes, a confrontation, we talked after
Okay. Who did you have a confrontation?
Colonel McCrary sitting right there.
Could you,
Objection, Your Honor. I would like to also, there was one single photo lineup, which he seen my picture prior to this exam. It was a photo lineup single. And this is how, you know what I mean, he's my brother, truth. There's a procedure on the due process. Oh, okay. Yes, I would
I don't
like,
have that issues, right?
I mean, I'm good, but I would like to object because there was a suggested photo lineup used. If you look at this discovery, it says that a single photo was shown to Mr. McCrary. And this violates, what is it?
Let me get this straight. Well, let me get this straight. He's objecting to the identification as like the police putting in an implication of bias against his own brother for the purposes of identification. I mean, I feel like if it's their brother, he probably would know. I assume this is the victim. Is his brother the victim? If the brother's the victim, I feel like the brother would know whether or not it's his own brother who tried to kill him. I don't think but I don't think the brother's the victim though. But anyway, I think his brother is the victim. God, I hope it's not for both counts. Is it just for the attempted murder charge, or is it both counts? I really hope it's not both counts.
States versus Wade, I believe it is.
It would be way to address that. However, Mr. McCrary, that's fine. It's very delicate for you to represent yourself. But you just stated that he's your brother.
I mean,
he just put it on the record. He did just put it on the record that he's his brother.
I mean, this is one of the most easiest identification cases. If he knows you as your brother, he can identify you from that day.
but it's still, it's suggested, it violates the law.
We're not even getting to the law.
Wow, thanks, Mike.
I hear you. So, continue with your questioning.
Exactly. You didn't ID you from a photo lineup. It's your brother.
Could you describe clothing that the gentleman?
He has a blue jean jacket that I had.
Your Honor, let the record reflect that witness has identified the defendant.
It's not reflected.
What, at this address, you arrived at it, you had a confrontation. Could you go more into that?
Well, prior to seeing my brother Carnell, I had went into the house the day before on the 8th, and the downstairs door, which is the part that I had, was kicked in and damaged. So, and then I went into the back room, and the another second door was kicked in and damaged.
Objection, Your Honor, he just committed perjury. The first door is not kicked in and he speaks of.
Sir,
Oh, okay, I'm sorry, I didn't know I had to say it, I'm sorry.
what you're doing is you're testifying as to what happened.
He is testifying.
All you can do in this case, if you're
Because he's not just objecting. He's trying to restate on the record. He's trying actively contradicting what he's saying, but that's giving testimony. That's not simply an objection.
saying that he's not telling the truth, on cross-examination, you have opportunity to question him and possibly raise issues of credibility. But at this time, you're testifying as to what happened and not an objection regarding the rules of evidence. Okay? Every objection has been placed.
I understand this, man. And if I may finish, though, upon going into the kitchen.
Second. Describe this house. Is there like is it an apartment?
It's an income bungalow. So it's an upstairs and a downstairs, and they're separate, and they both have separate utilities. And the downstairs is the part of the domicile that I was having. I became executor of the estate, so I kept the house so that my other siblings, including him, could stay there.
Okay.
So I came downstairs.
Say him, who are you referring to?
Cornell McCreary. So when I came downstairs,
Just so the record's clear, whose estate are you talking about?
my deceased mother's estate, Mamie McCreary.
Who lived up? Did someone live up in the?
Cornell McCreary stayed upstairs after he was released from prison.
Okay. So you came in and there was damage?
Yes, there was damage to the front door, the kitchen door, and a bedroom door.
Okay. What happened?
Okay, so
This is on the 8th.
yeah, so I didn't have a camera with me at that time to take pictures of the damaged property. So I came back on the 9th, and then once I came back on the 9th, I took pictures of the damages that were incurred in the house.
What, after you took the pictures, what did you do next?
I left the house and then I went next door to one of our neighbors she had fell sick and she had a pacemaker. So, she grew up, we grew up with her. She's like a mother.
Okay.
So I went next door and, visited her. And then upon leaving, when I was coming out, my brother was coming, Cornell.
Okay.
Anonymous, thank you for the $5 tip for the kitties. Thank you. Speaking of Winston, what? Are you being a kitty?
You were coming out of the neighbor's house. Where was your brother?
He was coming out of 1417 home.
Okay, and that's where he lives. Correct.
He lives in the income bungalow upstairs.
Okay. What happened when you got it?
He confronted me and, I told her, I said, so is this how you're gonna do our mother's house? And he was, he started talking about taxes. which he hasn't paid. You know, so and then I was like, you know.
Okay, so it sounds like assuming that his brother, if OSG is right, this guy and his brother's a Moor. He sounds like he's a non-Sav Sit Moor, which is a thing. I always try to point out. If he's a non-Sav Sit Moor, then he doesn't engage in the mess that more sovereign citizens do.
And I try to ignore him. So he's like, yeah, so you going to go to the police on me and all this kind of stuff. So, and you know, I was like, yeah, I'm going to the police. And he's like, well, somebody's going to die today, me, you, or the police.
Okay.
So, and then I ignored him. And I went to my automobile.
Okay.
And I was about to get into the automobile. He picked up.
When you got into your automobile, what happened next?
He picked the brick up and hit the car with the brick.
Oh my God!
I jumped out of the automobile and you know ran after him, and he ran. So you know, I was like, man.
Okay. Where did he run?
He ran up on the porch of 147 down.
Okay. You sit tight, Your Honor. When he ran up, what did you? When he's on the porch, what did you do?
I went. You know, I ignored him and went back to the car because I was going to go and file a police report.
Okay. And when you went back to your car, what happened next?
He picked the brick up again and hit the car again.
Oh my God!
So now this time.
Okay, so far, the defendant allegedly kicked down a door to this two family house. It sounds like. He said that one of us is gonna die today, either you, me, or the police. And then so far, he allegedly threw a brick at his brother's car twice.
I ran after him again, and he ran up onto the porch, opened the door, and then came outside with a semi-automatic weapon and fired into the air twice.
Okay.
And then now he took a gun and fired into the air.
And then
I'm sorry, did you say into the air?
Yes, into the air twice. And then he looked at me in the eyes and then pointed the weapon at me and shot in my direction.
Oh my God.
And, you know.
When he shot in your direction.
Holy hell. He tried to kill his own brother. He really did try to kill his own brother. Yikes.
Where did the bullet go?
It's a field right across the street from the house. So I can't say where it went, but it went in that direction towards the field.
Well, what did that do to you as far as
I was first of all, I was upset that my brother would do something of that nature. Then, you know, I kind of feared for my life, so I jumped into the vehicle and drove off.
And you said the weapon was what type of weapon again?
It looks like it was a rifle, it was a black. It could have been an AK.
But you're not sure, right?
No, I'm not sure.
Okay. And after you got in your car,
I was really upset. You know, I went directly to the precinct and I filed a report.
Okay.
And
I have nothing further for this witness at this time, Your Honor.
Ross, does that make sense?
yes, I make.
This will be fun. Jeez. OSG and I had this are synced.
I just want to let you know, you are bound by the rules of evidence. If the prosecutor objects, if you need any help with it, Mr. Washington is there. Okay?
How you doing there, Norman? McCurry?
I'm here.
You all right today? Okay, let me direct you. You stated that I shot in the air. Is that correct?
That's correct.
Okay, isn't it also correct that you said I shot in the ground as well?
I didn't see you shooting at the ground.
Well, no, I'm just saying, is it yes or no? Did you say I shot in the ground?
I didn't see you shooting at the ground.
Okay. Your
It's
Honor,
not a yes or no.
I would like to reflect for the record that at another proceeding, the prosecutor stated that he said that I shot the ground shot the air and shot him 3 stories. Okay.
Your Honor, I don't recall that, and
This
today
was
we have to
a,
go by testimony of the witness, and that's what we're here.
So
well, you were the spokesman for it.
I represent the
representing
people,
him.
so.
Okay, that's all right. Okay, you spoke about a probate issue. Am I correct that you were the executor, sir?
Yes, I did.
Okay, isn't it true? Have you ever committed perjury or have you ever committed forgery or anything that nature? Oh, Your Honor, you just lied. Here's the paperwork, this impeached him with, isn't it true that you forged, my name?
What does this have to do?
oh my god.
Well, you impeached me.
So okay, so he's trying to impeach his brother, and you can do it. Yeah. Crimes of I forget what the general way to call it is. But crimes of like deception, such as like fraud, forgery, those kinds of crimes. They may be prior bad acts, which normally would not be permitted under bad character evidence on the and the rules of procedure or rules of evidence. But when you're trying to impeach somebody's credibility, you can bring in those kinds of crimes because they go towards the individual's it goes towards the individual's proclivity to not tell the truth. So those kinds of crimes by like forgery, deception, because they go towards the person's ability to be truthful to a victim, they can be brought in to attack the credibility of their testimony. The problem is he's doing it all wrong. He's like jumping all the guns right now.
Sir, it's impeachment, sir. People versus Sandaway laws, the rules of evidence. Isn't it true that you forged my name, David McCurry? Paul McCurry, James McCurry, and Charles McCurry?
That is not true.
Okay, I have affidavits from him notarized where he stated that the brothers gave him permission to sign individuals' names, and the judge issued a show cause hearing. Give me a second, please. Okay, here we go.
No, you can't just say, Your Honor, you just lied. What you would do is, Your Honor, may I approach the witness, or at least you still need to authenticate the document first, assuming if he didn't even bring it to the state. But you would but even let's assume that the document has been authenticated, right? You would say, Your Honor, may I approach the witness? Are you familiar with this document? Can you tell me what the document what this document is? And go from you would force him to admit, you would force him to read what the document is. You would force him to kind of state it, because it works better. It works better to get the witness to admit to what they did wrong, rather than just tell it yourself.
To get a copy of to the prosecutor's office is signed and notarized by Norman McCurry, and this is allowed for impeachment purposes.
You would say, because you would go to him, is this your signature? What is this document? Is that your signature there? So isn't it true? So it's true that you had to admit to this crime of deception previously.
With a perjury on the stand, Judge, and on page 2, Norman said that the other brothers, Charles, James, and Paul McCurry, agreed to getting the loan, the signing of their names. Oh, okay, yes. Could you, I'd like to give it to your witness and see it too. You just lied on those, sir. And it's signed and notarized by him in the Wayne County probate proceeding.
That was forged by the judge. It was not, and I had to follow the judge.
Oh my God, no!
And I have an affidavit from my brother on the phone too that he didn't give me permission as well. And I'd like to have that's what I was saying about witness call, Judge.
Okay.
It's just an affidavit. It doesn't show anything about perjury. And not only that, but
It's forgery, sir.
One second, Mr. McCray, one at a time.
in order, the court rule, in order to be impeached, there has to be conviction. Therefore,
Yes, exactly. Yes, I was. So he's just making an allegation that he forged a document. It's not even I thought it was like a plea agreement or a sentencing agreement. It's just. It's just this whole freaking allegation. Oh my god. Oh man. Kill me.
I'm gonna object to this line of questioning unless the defendant can show that the witness was actually convicted.
Where is that case law? Show me the authority by that, that's why.
The court rule.
Oh.
He just like.
Tones, all right. Tones, this whole exercise, this is what I mean when sovereign citizens and auditors are like the textbook example of Dunning-Kruger. Is like they know enough to feel arrogant to think that they know everything, but they don't. Because see, this guy, he knows enough, just enough that he can impeach his brother's testimony by bringing in prior bad acts, right? But the prior bad acts is supposed to be convictions. It's supposed to be prior, like, criminal acts that have been that he's been found guilty or he pled guilty, or some sort of legal stipulation as to an act that he committed wrong. So the reason why he's bringing it up is that he's trying to impeach his brother's testimony of what he allegedly did. And the way you do that in this is to bring in the prior bad acts rule. And what I said earlier is that bringing in prior bad acts of crimes of deception, like forgery, like for example, forgery or check fraud or something like that. But that's not what he's doing here. What he's doing is he's bringing in an affidavit, either, I can't recall if it's signed by him or allegedly by his brother, that his brother allegedly forged his name in a probate action. That's not how this works. So that's the whole reason. The whole reason why he's bringing it up is he's trying to impeach the testimony to attack his brother's credibility of his testimony, but he's doing it all wrong.
And he lied under oath in the courtroom. That's why I don't like this subpoena.
Let me finish addressing the objection. Under the Michigan Rules of Evidence, to attack someone's credibility and to impeach them, you have to do it under whether or not the witness has been convicted of a crime involving dishonesty, false statement, or theft. If there's no proof of a conviction, I'm not sure how you plan on proving that with an affidavit that has not been verified by anyone. No court other than an affidavit signed by another person.
Yes!
Here.
Yes, thank you! Thank you, OSG! Just like you, Mr. McCreary, your brother is also innocent until proven guilty. You can't just like throw in an affidavit like, aha, he lied. See, he forged names here. That's not how that works.
To testify.
This is affidavit. This is what I'm saying. It's signed and notarized. And then I was also previously, I have transcripts where I impeached police officers in Wayne County from complaints about them, and the judge allowed it. I just asked him, did he ever forge anybody's names and whatever else?
He said no.
And he said no. And the affidavit shows that he said my other brothers agreed. I have affidavits from Charles McCurry and other people that say they didn't give him permission. This is a felony. This is a crime, Judge. How can you allow this gentleman to come in here?
You have to file a police report for that crime.
I tried to.
Well, I can't.
They ignore. They've been vindictive to second prosecution.
I'm I'm not allowing you to present an affidavit. There's no conviction of the three things: dishonesty, falsehood,
Okay,
and
can you
theft.
show me in the rules of evidence where that is? It says about convictions, because other courts, I remember, I can't think of the chief judge from '99, he was here, he allowed.
1999.
Yes, Capers P. Harper was my attorney at the time. There was a deputy sheriff named Clifton Neely. And we asked for additional discovery to impeach him. And the judge allowed it at the time. I have this document at home as well. This is for purposes of impeachment. He just lied and said he never forged nobody's signature. And that doesn't equate to conviction or not. I have affidavits saying that, yes, he forged my signature, he committed felonies, and he did what he did. And this is his affidavit of truth.
Saying that he committed felonies?
It shows that he said.
Yes or no? Does it say he committed felonies?
Yeah, right here. It says that Charles and them agreed for him to sign their names. My brother has an affidavit saying that he did.
That's not saying I committed felonies.
Forgery is a felony.
I know it. So
Perjury.
telling me you're gonna kill him, so there's murder, there are a lot of crimes.
So that's discrimination on your part.
If it hasn't been proven or established, then what do you expect me to do?
Well, I have the affidavit showing this contradicting what he's saying per my witness,
For the rules.
Charles McCreary, and I would like to admit that in evidence as well. Because he's saying that he didn't forge these people's names, and my other brother's saying that he did. And this for purpose.
Michigan rules of evidence.
And can you give me the rule?
609.
609, okay.
609.
Go here. You just lying under oath this time. MRE 609.
Wow.
For purposes of attacking the credibility of a witness.
I'm not sure, Joshua. I really don't know.
Convicted of a crime shall not.
It could be that they'll say it's a civil matter, but I don't know.
Or established by the public record, finished during cross-examination, and the crime contained an element of dishonesty or false statement, or the crime contained an element of theft, and the crime was punishable by imprisonment in excess of 1 year or death under the law under which the witness was convicted. So the issue here is that there was no conviction. So
yes,
I'm not admitting that evidence.
So the rules of evidence explicitly requires that if you're going to bring in prior bad acts in terms of to impeach a witness, it has to be via a conviction, not just simply presenting an affidavit.
Can I
Move on to the next question.
Can I give you speak about the rule?
I'm denying objection. You can place that you disagree and object to my sustaining the objection.
Yes, I do object, and this goes also, again, I would like to renew my motion to recuse under People versus Crampton, Michigan.
Oh my God, he wants to recuse her again.
Kane versus NBOC, because this court is being biased, and there's previous proceedings where the court allowed these types. Yeah, under in this court in 99.
I guess I guess instead of Daryl Brooks, he's trying to channel Blandino.
What I'm saying is I asked him a question. He said no. I have evidence to show he did.
I have evidence under
And it
Michigan
involves-
evidence 609 that allow for you to establish that. Next question, Mr. McCreary.
Okay, now here you just spoke on the rule, and I would like to argue the rule. It says unless solicited, I solicited from him and it dealt with theft and dishonest crime. And this court, I feel, is being biased toward the prosecutor.
You're sounding like a broken record. I heard you already.
All right.
Denied.
Okay. Can I continue? And I object again.
Please.
Mr. McCurry, isn't it true that you consider yourself a sovereign citizen?
What does that have to do with this case?
Well, it's relevant.
Uh-oh. 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 Oh, no. Oh, no. Oh, boy. All right. Now it's going to get juicy.
Goes for credibility impeachment, Your Honor.
I object to the relevancy of the question.
It goes to the credibility of the witness and to test his credibility.
So sovereign.
People versus
sovereign-
sound. People
Mr.
versus
McCreary,
sound.
the case law, you can stop right now. Rules of evidence. How is this relevant to the case here today, whether he's a sovereign citizen? And don't say anything about dishonesty, because you are too, and you've established that. I said,
Oh, no, oh, gosh, don't say that.
Judge, you're not. Oh, Judge, the judge let the intrusive thoughts win. Don't say that, Judge. No. She said, "Oh, you're a sovereign citizen too." No, you can't say that. Now he might actually have a case against for bias. No. Thank you for the $5 tip. Stream of numbers. Tell the kiddies that there was once a doggo that would love to meet him. His name was Sully, and he was the absolute best. I'm sorry to hear that. Whoever you are, thank you for the $5. Because in fairness to a lot of these sov cits who don't like to be called sov cits, sovereign citizen in this day and age does what do you well, I mean, would it really be biased? I mean, it's not like the jury's here. This is a pretrial examination. This is not a trial. This is a pretrial examination. But there could be there's a stigma. Thank you, Archangel. There's a stigma that does go with the nomenclature of sovereign citizen. So that's why there could be a motive there. As much as I love her for the mic drop moment. She let the intrusive thoughts win.
Don't say that it's about design, because you stated you're a sovereign as well.
I mean, yeah, I agree.
So
I'm
what's
not
relevant
the
of
straw
him being a
man.
sovereign today?
I'm
while
not
this
the straw man.
Okay. Now she's right that he did in the previous he called himself sovereign. He did mention sovereign, so that might actually let go of the sting a little bit when if he admits in open court that he is sovereign. But she said, well, a sovereign citizen, what's the difference? So that can lessen the sting of a potential issue of bias right there. So okay, I see that. Now he's saying a lot of these sov cits say, "Oh, I'm not a sovereign citizen. That's an oxymoron. I'm sovereign." You know, they try to make that sort of a distinction in court.
Good question. How is it relevant that he's a sovereign citizen?
Because he's the same person that fights you guys. In court, he's issued. I'm indigenous to this land.
Both of you all. In a minute, in this exam, it's gonna be.
Oh no!
You all don't stop.
Oh shit! That thunder was actually very close by. Thanks, Ball. Thank you for the 5 gifted memberships. Thank you very much, Angst Ball. Well, I guess my APC is or APS is going to be useful then. But if the stream cuts out, you'll know why. Because this thunderstorm is right here.
I don't care if he's a sovereign citizen or not. That has nothing to do with the case here today.
Ultimately, whether or not his Moorish brother is a Moorish sovereign citizen is ultimately irrelevant to the charges.
So I don't find it to be relevant. So next question.
So you stated that I shot in the ear. Is that correct? Yes. Okay. You also stated that I shot at you as well. Yes. Okay. Is there any witnesses to this? And what time was this alarm? Well, I can't remember this young man's name, but him and his mother was outside. Okay. Okay. So what time was this? I can't remember. You can't recall. Does the people have this information, Judge, if he doesn't know the time that this occurred? Because on this day, I was at work. It was around probably after 5. You just said you didn't know, Mr. Bryant. I said I don't remember, but if I try to recollect, then I would say I get off work at 4:30, so it had to be after 5. Okay. Are you familiar? Do you recall that I worked at Oak Park? I don't know. I didn't know where you. You very okay. Now let me ask you this: for your birthday, didn't I get you 2 bottles of rosé for your birthday? And I told you about I got a
Objection.
Well, no, I'm trying to establish that he knows that where I worked at. This is what I knew that you had got a job, but yes,
at a supermarket.
Yes, you
Okay.
did.
To the McCreary's. If there's an objection on the floor, everyone has to stop talking.
Thank you.
For a couple of reasons. The court reporter, you are torturing her right now because she cannot take down anything when everyone's talking. So please, one at a time. There's an objection on either side.
True.
Stop talking. So there's an objection. What is your objection?
Honestly, whenever there's a soft sit in court, I feel like a court reporter should get hazard pay.
Relevancy.
What is the relevance of the 2 bottles?
Time and a half.
To establish that he knew where I worked at, so that I can let it be known that I was at work during this time that he claims whatever this stuff is going on.
Okay, even if he doesn't know where you worked on that day and time.
Okay, this is what I'm
It's not
trying to.
relevant as to the day and time in which you were at work.
Well, the time of the crime that he stated. I mean, how do you not know what time the crime was committed? You saying the date, but what time?
What time was you worked, where you worked, or the time?
Well,
of the day?
what I'm
Because he
trying
said after 5, it had to be after 5 if you worked until 4:30. He doesn't know the exact time. Is that my understanding of what he said? Is that correct?
Well, I worked afternoon.
Is that correct? What he just said?
Pardon?
He said after 5 because he gets done with work at 4:30. Not sure what time, but somewhere after 4:30, after 5. Is that correct?
I mean, this is what he stated.
That's all I want you to say. We all agree on what was said. Okay, so he doesn't know the exact time. I understand. Next question is, how is the 2 bottles of rosé relevant to the day of the
Well,
event?
the reason that I stated that, Judge, is because he knew where I was. I was telling him about how cheap things were there with my discount. So he just stated he didn't know where I worked, but he knows where I work. Because I gave him 2 articles from the job for his birthday.
Okay,
And then I have witnesses that I would like to call in: Robert Van Dyner,
okay.
Gerald
You can call that
Flowers,
when
and
it's
other
time for
people.
you to roll with
Yes, because Mr. McCreary was paid money. This is why
Mr.
he's
McCreary.
okay.
Last
All right,
question
okay,
for
okay.
cross-examination.
Mr. McCreary, isn't it true that you allowed Mr. Robert Van Dyner and Gerald Flowers to rent the downstairs at some
I'm
point?
gonna object to relevancy.
Well, I'm trying to establish that Mr. McCreary is committing crimes, past and present. This is what this is about for purposes of.
But that's still irrelevant. Jason Heaton, thank you for the 10 gifted memberships. Jason, a lot of folks gifting memberships. I appreciate you guys. Appreciate you guys sharing the love. Eventually, once I I think on the about 4 days I should be I should get my check, and then I'll take care of medical bills. But it's irrelevant for him to try and bring up, oh, he committed crimes in the past. It's what's relevant is what happened on that day.
No, for impeachment, I read the rule, 609. Unless you have some other route, you asking questions about.
Well, the thing is, he's stealing money. If you look at the tax, like the tax is stealing my mind.
And guess what?
After
Even
10 years,
if
20
he
years.
was stealing money, it wouldn't be relevant today during this testimony.
So he can steal from me, and that's okay. And other people, it's okay.
No, it's not okay.
And I've made reports, and the 10th precinct is retaliated because I made reports against their officials down there for failure to protect.
You are
Judge.
muddying the water, not staying focused on what has been charged on this case.
Well, I'm being denied my rights. This is what I.
So I am going to sustain the objection, it's not relevant. Question.
Okay, isn't it true, Norman McCreary, that the taxes mainly McCreary are still in her name after 20 years of being the city servant?
Yeah.
No, this your witnesses committed felonies, and you're committing felonies with them. You don't care what.
Okay.
And there is documented. I'm just this purpose of
It's
it.
just this, well,
The purpose of it.
okay.
May I ask you a question? How did you come to work here to court? How did you get here? Did you drive, or were you brought?
Objection, Your Honor, relevancy.
Relevancy is Mr. McCreary is driving. He has no license. And
Okay,
he's
are you
breaking-
just trying to
he's breaking-
tattletale on him for
No,
everything
I'm
he does?
impeaching.
Right? Exactly. he's
he's like ratting on his brother for every single transgression on the stand.
I'm being accused. I'm innocent.
Okay,
I'm innocent,
it's still not
Judge.
relevant to the allegations and to what he testified to on direct examination.
Well, if I may respond, the relevancy is that Kim Worthy had
Thank you for the $6.90 tip, Anonymous, or AKA Lori. Really enjoying this.
executed things against police officers, but the witnesses are being allowed to commit perjury and get on the stand. This violates the officer's right, equal protection clause of the 14th Amendment. Because if officers have testified or lied and they were convicted,
What does the officer have to do with anything right now?
well, this is the witness.
He's not an officer.
He's a witness, though. It's just
It's not the same. This was a very specific case. We have specific testimony. I don't care if he has a license or not. So sustain.
Well, what I'm saying is,
I don't care if he has a license or not.
well, the police and him, they're being allowed to commit felonies, but I'm here to be accused. And this is,
You
I'm
have
trying
been
to establish.
You're not being accused. You have been.
Okay, I'm being accused. I have been accused. Yes, and there's no evidence. Mr. McCurry, can I ask you a question? Did you know that there's no evidence in this case?
What the hell kind of question is that?
Why?
He's not an officer.
What's this stupidest? What the hell kind of question is that? Are you aware that there's no evidence of anything in this case? Andy, thank you for the $5.
Well, I'm just saying, there's no evidence.
And actually, there is evidence.
Where is this here?
Your Honor, his testimony is evidence.
That's not
Let's
evidence
see
under Upper versus United States.
Under the mission rules of evidence, testimony is evidence. Next question.
Okay, may I object under Upper versus United States? Testimony without cooperative evidence is not evidence.
Yeah,
Jackson
so
versus Virginia,
That
and Wade.
is incorrect. Next question.
I just say I'm being lynched today by this court as well as my brother.
Is this your closing argument? Because you can say that.
Well, I mean, you won't let me bring nothing in. You're shooting down everything that I've brought in.
Hey, all right, thank you for the $9.99 super chat. I'm an hour and 10 minutes behind. Judge Bryant denied recusal. Heard Judge Middleton once before. Can the family court judges not do the same? Big into the two Karen's mom series is why I'm asking. I mean, I don't know. It all depends on Michigan. And Michigan's rules when it comes to recusal and whether or not different sections have different rules when it comes to that. I really don't know. But thank you for the $9.99, RA.
Because of judicial bias.
It's not
Other courts have
under the
hold
Michigan court rules of evidence, under the Michigan court rules, under the rules of evidence. So I'm not lynching you. I'm denying you certain things that you're doing because it's not applicable and proper in court.
All right, now may I respond to the rules of evidence statement that you
No,
made,
you can
Judge?
ask the next question that's relevant to the exam you're taking.
Well, I mean, I can't ask everything. You shoot down everything I bring it, Judge, and I
If you don't have
object.
any more questions on cross, then you can say no more questions. Have a seat. If you don't have anything
I'm
that's
being
relevant
denied.
to the direct test, the direct evidence that was provided, or the testimony on direct.
Well, may I address something that you stated, Judge, if I may?
Question to the witness.
I mean, I just yield because I'm being denied my rights, and I object to this whole proceeding because I'm denied to present evidence and call witnesses on my behalf.
No, you haven't been
To
denied.
properly
The people haven't
cross-examine,
requested for you to
to
even
properly
present
cross-examine the
any
witness, and then you're charged me with strangulation. It says injuries. No, this man is not hurt. He hasn't been shot. They got weapons and strangulation. I do all this to him and stuff.
They're not accusing you of battery. They're not. They're accusing you of attempted murder. Attempted. It doesn't matter whether or not he's still alive. The allegations that you attempted to kill your own brother.
Bro,
So,
this is what I'm
you
trying to
weren't
understand.
charged with strangulation.
Yes, it's in here.
It says or by strangulation.
Okay, but what's the first part?
Assault with intent to rape by the mind.
Okay, assault with intent to grave bodily harm. He has not been hit. He hasn't been hurt. He hasn't been anything happened to him.
Oh my God.
So get to that in the argument. You'll learn elements. of
I
that.
mean,
That-
I just object and I'll rest and I'll leave it to the circuit court as
But you
well
can't
as.
rest. You haven't even had an opportunity.
Well, I'm
to
just
present
saying
witness. Do you
because.
have any more questions of the witness?
I mean,
You
I'm
re-
denying my
He
right.
didn't say he tried to rest. We're still in. We haven't even had trial yet. Oh my God, he's such a moron. He's such a moron.
Or, no, you have any more questions?
No, because I'm denied the right to proper cross-examination.
Can you redirect?
No redirect, Your Honor.
I think, yeah, I'm gonna say that they probably hate each other.
Do you have any witnesses?
I would like to call the chief officer that's the investigator on this case, and also
Jason, thank you for the $50. Jason, thank you so much for the $50 tip. For the kitty. Thank you so much, man. It really helps. It really does help. Like I said, all the bills are all paid up. I just had to use my Amazon card. Luckily, I'll get enough points. I'll get enough Amazon points from that purchase that I'll be able to get a new set of headphones with it. You know what I mean? For without cost. Yay! But thank you so much, Jason.
I'm not calling any other witnesses at this juncture because there's a witness list. And I would like all witnesses to be brought here so that I may properly examine and cross-examine these witnesses because they don't have a warrant, judge. Like after we had the hearing when he attested to court, I just had 15 pages. This is all that we have. Where's the warrant, judge? How am I charged? Where are magistrate's signature?
So as far as this is the probable cause here, this is not, let me finish. This is not trial, okay? So the people do not have to present anything but what is the show probable cause.
Okay. Okay. Now that I figured this out, we're at I knew this is a pre-trial hearing, but this is a probable cause hearing.
So if they want to call one witness, they can. You want to call the officer in charge of the case?
Well, can I call all the policemen that are on the list? Since he's not calling.
You need to offer of proof.
Pardon?
Offer of proof as to why you need to call them.
Well, because their investigation. This is what I want to question them as their investigation. How now the law is, I cannot be tried for a crime that I haven't been charged with. There has to be a complaint, warrant, and a request for a warrant. And there's not anything here. How was I even charged, Judge? And there's no warrant.
So,
and out of the 15 pages, I looked, and that's a violation of the Fourth Amendment to the U.S. Constitution, Judge.
Great. You said you wanted to call the officer in charge?
Yes, the officer in charge.
Okay.
And the other officers.
Now, I will allow for the officer in charge because he's here, correct, Mr. Walker?
Correct.
Okay. For the rest of them, you did not subpoena or bring anyone today.
Well, I didn't know he was not going to put them on here.
It's not his job to call your witnesses.
No, what I'm saying is they're on his list as witnesses, and I would like to basically get the court to have
He did not provide a witness list for an exam. In discovery and investigation report, I believe, is that what you're referring to?
Yeah, right here, the prosecutor's office witness list. I have a right to this.
Okay, so you have a right to interview them and subpoena them to come to court.
Oh my God, he's an idiot. So if you're missing what's happening here, he never bothered to give to have a witness list to subpoena for his own case. It sounds like he said he was just going to simply rely on the prosecution's witness list to be able to cross-examine his own witnesses, cross-examine the prosecutor's witness. But what he wasn't anticipating was that the prosecution's like, we don't have to, the prosecution's not obligated to bring up every single witness on their list. If they feel that they got enough for probable cause simply by his own brother's testimony, then they don't need to bring in the lead detective. So he screwed himself. So because they didn't bring him up, he didn't bring his own witness to subpoena, he can't bring up the detective to testify just because they're on the prosecutor's witness list.
Well,
you ask the people to make them available to interview also before.
Yeah, I understand.
Okay, today we're here.
Well, in the
And-
6.10, it says I have a right to examine, cross-examine the witnesses of the prosecutor as well as myself.
You do.
And they had an investigation. I would like the court to have a clear understanding so these charges can or cannot be established properly under the due
I
process.
will allow you to call any witnesses that you have subpoenaed that are here today, as well as the people's witness who is officer in charge on this case with officer. Would you
Man.
call that?
Oh, yes, but man, I object to the court's denial of my Sixth Amendment right to call witnesses and also in the MCR 6.110, because to establish.
So now he's saying he's objecting to his denial of his Sixth Amendment right to call witnesses, even though beforehand he did have the ability to call witnesses. He just didn't put them on. He didn't subpoena them. And guess what? This is the consequence of trying to be your own attorney when you're not an attorney.
A proper investigation, this court to be full aware of what is going on with this case and evidence concerning this case. I mean, these officers have to be brought forward.
No, Nathan.
Investigation.
And I believe that is a matter that you may, if it gets bound over, can address at trial. There were several motions. It's the proper cause here, Mr. McCurry, very minimal.
Well, I mean, the rules are clear and under due process,
They don't seem
statute
to
of
be
due
clear
process.
because you still talking.
Well, may I address the court? I mean, you give him the full rights to speak, but I'm always cut.
Bro, you have been talking at least 70% of this entire hearing.
Well, it's because you're saying things that really aren't relevant. So the officer in charge is here. Do you want to call that person to stand?
I definitely will.
Step up to the court reporter, give her your name and spelling.
I swear you swear to tell the truth, no truth, and nothing but the truth.
Yes, Your Honor.
And sit down, just make sure you speak up in the mic. Whenever you're ready, Mr. McCurry.
Can
Can
you
you
give me,
like this, sir?
pardon? I hear you. Can you give me your name and badge number for the record, sir?
Officer Edward Wowski, -4753.
You say Pulowski. Okay, so you're the officer in charge,
Yes.
detective? Okay. On the day in question, what time did Norman McCurry come into your station to make? If I'm
I don't know the exact time, he been right at the incident.
right after this, then, so you didn't take the initiative to write down what time he came in here? He came into your office?
Your Honor, I'm gonna object to foundation. It hasn't been established that this witness actually took the report from the witness.
Okay, so where's the
Let's
other?
clarify that.
Okay, I would like.
Lay a little bit of foundation as to
Well,
what
if
is
he-
involved in
If
this.
he's the head
Mr. McCurry,
officer. Okay.
lay a little foundation, which means ask questions about his involvement to get to
I
the fact
understand.
that you're questioning whether he knew it.
I understand.
Exactly. He doesn't know what he's doing. Again, Dunning-Kruger. You're supposed to lay the foundation, like, because he has his name and badge number. How long have you been working for the police department? Were you involved in this matter? How were you involved in this matter? And then just basically laying the foundation that he was involved in this so that everything that he's testifying to has some level of relevance.
Okay, did you, are you the only one that had contact with Mr. McCurry?
No,
Okay, may you tell me whom Mr. McCurry started having contact with, in the beginning?
the officer Clannon who was working the desk.
Officer Clannon. Clannon?
Clannon,
Oh, Clinton, okay,
Clannon.
Clannon, okay. So you took the report, or Officer Clannon took?
Officer Clannon took the report.
Okay, and this is the report that's in this file that I made, this report here, sir?
You wanna,
I mean, I'm just asking, is this the report that the
I don't
officer
know,
took?
can you see that report?
That's not a report, so that is a written statement.
Or written statement?
Yes.
Well, it says an interview, like, it's questions are asked, and then the officer is writing the questions, then he's writing the
I'm
answers.
gonna object because it hasn't been established that this witness has taken that.
Well, he's the chief officer in charge of this case, so everything falls on him, just like you're subordinate of Kim work, sir.
No.
Everything you do falls on her.
For the-
Oh my God, shut the hell up.
Well, I'm trying to establish time, place, and things of that nature. I mean, there's allegations.
Let's stick to the very specific question you're trying to establish with this statement. What?
Well, I'm trying to establish a time frame. When did he come into the office? When did he speak?
Okay.
Who did he speak with? What time reports were made? You know, to clarify everything Mr. Norman Query stated.
Okay.
So I'm trying to lay a foundation as to this investigation.
Okay, and that's not the document that the witness has prepared or is familiar with, because if he didn't prepare that, then you can't present that to him and tell him to refresh his memory or recollection about it.
Well, no, I was just asking what time did Norman come in to make a report.
And your response was you weren't sure.
He said he don't know, so.
Yes, I mean, this is one of probably 300 cases I've had since then. I don't remember the time of every case that I have. It's all in the reports, which is public record.
Okay, so do you have the report?
Well, talking about for this report here, yes.
The witness just stated that he's not sure what time, but it's in the report. You have that report that he's referring to.
It says, I can't understand this reading. I mean, can you understand this? I mean,
Just-
5, it says end time.
Don't read to me on.
Oh, it
on
says
the-
start time was 5.
Mr. McCreary, when I read to me what's in the document, do you have
Yep.
it?
I have a police report, yes.
Okay,
I believe he still has a statement. If it's written pen, it's a statement. The report is all typed.
Well, this was taken on the 10th, Your Honor, the day after the fact that I was.
You got your-
Stop talking.
It's all in the jacket. There's an investigative report, there's the police reports, there's everything, the warrant.
Hey, Phil, thank you for the 1337.
He said he gave me
Help with Archer. Even my Roddy is not a fan of cats.
There's no warrant here. There's no authorization from the prosecutor here. And then if he pulls anything else out, that's a Brady violation.
okay, you may have it. What it's showing.
It's not here.
You don't even know what he's about to show you.
Oh,
What I have, that was in the packet, discovery packet, is the Troy Police request for a warrant, investigators report. It starts on page 3 and appears to go through page 6.
There's a national report you just had.
And this is even signed by the prosecutor, where they recommend or deny a warrant request. This is not even signed, it's not notarized, these documents are not
Okay,
legible.
let's stick to, do you want to
Yes.
present that report to refresh
Well-
his recollection about time?
Well, no, I was asking him.
But that was the line of
No,
questioning.
that
we were on.
was not where I was trying to go. Where I was trying to go, I was asking him to get a basis. He stated that Mr. McCreary, my brother, came into the police department and made a report.
Yeah.
This report showed that he gave a statement on the 10th, so how it happened on the 9th? He said he went in there on the 9th, and this is written on the 10th.
That would be the day after. This is you testifying, first of all. There's been no testimony that
Okay.
anyone came on text.
Okay, well, look, I'm just saying he's objecting to everything, and I have foundation and right to ask these questions.
Ask about that.
Okay.
what does it matter whether? What does it matter whether he went to go take the report the day after the incident? If the report was before the alleged incident, we might have something to talk about. But if the report was taken after the incident, what does it matter?
Okay, so you stated that you're the chief officer in charge of this case, am I correct?
I'm the officer in charge of this.
So you just stated under oath that you didn't know what time that Mr. McCreary came to the police precinct to make a complaint. Am
Not
I
the
correct?
exact time, no, sir.
Okay. Here, I would like to impeach him. Did you guys seek a warrant from Kim Worthy's office on this day in question or at any time?
I don't remember what date I sent it exactly, but yes, we sent the entire packet over to the prosecutor's office.
Okay, at your, what's the word? At your direction, did you order your officers to arrest me on the date in question, which when I was brought in for this case?
I didn't tell them exactly what day to arrest you. Once we do any kind of felony case, I gave them my special operations unit who works out of the 10th precinct. I know that there's probable cause to arrest somebody. If they come across somebody, they'll lock them up on that case, yes.
Okay, was there a warrant, sir?
Not at that time, no.
Oh, is there a warrant now?
there should be, because you're a court.
No, sir. Right here, Judge, I would like to amend the evidence where right here, this is the Wayne County prosecutor recommendation. It's blank. It's blank. Now, my paperwork's supposed to be the same as his.
Your Honor, it is blank. The only thing that's different is that it's been redacted with the witness's address between his and ours. And that's perfectly legal, and that's to protect the witnesses unless there's a special.
You talking about the warrant, sir, not the protection.
I'm explaining why the difference.
I'm not a threat to him.
So.
And it's the last page of investigator's report, that's not going to be an actual warrant that's set in with every investigator's report.
Well,
The authorized warrant is going to be the black and white with all the charges.
okay, can I ask you a warrant where?
So there is an information.
The objection, that's not signed, notarized, or approved by court, the court rule.
That would be a motion that you can address if this gets found over regarding the warrant.
Right. Well, I would like to continue my cross-examination if I may, Judge.
Please.
How long have you been an officer? Officer Pulowski, you said it is?
In Detroit, over 7 years.
Over 7 years. Oh, you've been a police officer in another city?
Correct.
May I ask where?
City of Westland.
City of Westland. And you say you've been in Detroit. How long now?
7 years.
Are you familiar with the restrictions of the Fourth Amendment to the U.S. Constitution, Article 1, Section 11 of the Michigan Constitution, sir?
I just put for a record that the officer isn't an attorney.
Well, but he's supposed to be a law enforcement officer. How you gonna be a law enforcement?
No, you don't.
Yeah, I know about the Fourth Amendment, yes.
Okay.
Okay, again, was there a warrant when you arrested me?
I did not arrest him, sir.
Well, your officers, you should know what your officers are doing. Notice the agents, notice the principal. notice the
Question, what's the
principal, notice
question?
agent. Okay, did your officers have a warrant when they arrested?
No.
Judge, I move for dismissal at this juncture because there's nothing authorized by the prosecutor or anyone else. And he just stated he arrested me without a warrant. This is a crime. Now, I would like to state this. In 2001, the Department of Justice indicted DPD for drag that arrest.
Okay.
And it's
Okay, so you can be arrested without warrant. So that's the thing. You can be arrested without a warrant, but eventually you gotta but it sounds like they already put in an information, right?
it's
So
violation.
I'm denying that request. You can be arrested without a warrant.
Can you show
Yeah.
me the law where that is?
No, it's not my job to show you that.
Okay, well, I'm saying under federal case law and state case law under Article 111 of Michigan Constitution of 1963, as well as U.S. Constitutional Amendment 4, enforced upon us.
You don't need the reason why the reason why we're in a probable cause hearing is because it was a warrantless arrest. That's why we're here.
They have to have a warrant, Judge.
72 hours.
72 hours.
You could be held. Yes, you could be held. You could be held up to 40, depending on the state, up to 48 or even 72 hours without arrest.
Charged.
Well,
Or excuse me, without arrest, without charge.
But that's once again outside of the purview of this exam
well,
today.
they're committing felonies, Judge. This is the
Okay, and I am not the police department, I'm not the FBI,
May I
I'm not the
continue?
Department of Justice.
Okay.
The charges here today are assault with intent to murder, assault with intent to do great bodily harm, less than murder, or by strangulation, weapons, firearms, possession by a felon, weapons, ammunition, possession by a felon, assault with a dangerous weapon, felonious assault, and also 4 counts of weapons and firearms.
Okay. Give me a second. Okay, do you have any video evidence of when Mr. McCreary came into the station, like body cams, which are mandated by law, so far as the desk officer, or you giving the interview? Are these articles available?
There was no body cam footage used on the front desk. It was all recorded at the station.
Okay, within the station, why haven't you put that evidence into discovery so that the people could have it? Sir.
If anything's requested from inside the station, it can be put in there, yes.
Okay.
I'm looking for this page. Okay. May I take you to, I believe it's page 6, Detroit Police request for warrant. Can you pull yours off, please, sir?
I don't take anything, I'm not just taking anything.
You don't have anything, okay. Can I get the court officer to hand this to the gentleman so I may question him about this discovery investigation? Okay.
Last page.
Well,
Of
no,
the,
it's, I would like that back, but I would like to ask him a question when it concerns that.
So you want it back or do you want him?
No, I want him to look at it and I want to question him about it. But once he's done with, I'm going to be questioning him. I would like that back, paper back. That's all. Okay. Okay, you see the part right there where it says evidence officer. Can you tell me what that says?
None.
None. So how did you move forward if there was no evidence?
Mr. McCray, you established what it is to be.
Oh, okay, that's the, can you read that for the record, sir, at the top of the page?
Well, actually, you would have to ask some questions.
Oh, okay. Can I see yours, Mr. Prosecutor? What are you going to ask that?
Yeah, sure.
Okay, you have in your hand what's called a Detroit Police request for a warrant, am I correct?
Right.
Okay, on the top part it says admissions and confessions, what does it say?
None.
Okay, lineups, what does it say?
Single photo lineup showing Mr. McCreary.
Okay, evidence.
None.
Okay, and then you have the witnesses, then it says video, and you tell me what that says, sir.
Body worn camera footage not available due to the report being taken at the desk.
Okay, and photo.
None.
Okay. So is this typically how the 10th precinct operates? No warrants, no evidence, they prosecute individual citizens? Is this how this happens, sir?
So when I submit one of these,
That's a question, sir. I'm asking the question.
yes, this is
no.
typically what ours looks like when we send it in.
No, what I'm saying is this the procedure or the custom that your agency uses when they prosecute citizens so far as no evidence, no warrants? I'm saying, is this a policy or a custom with your department of 10th precinct, sir?
One policy just.
No, I'm saying that the operating of procedures so far as handling of investigations, prosecuting citizens when they're accused of crimes. Is this how you typically handle cases with no evidence, no warrants? You go get people. I mean, is this typically how your department runs?
Every case is different, sir.
Okay. Have you done this in your past history in Warren as well as Detroit, Michigan? Do you have a history of this, sir?
Sending it down warrants, yes, I have to.
Without evidence and without arresting people without warrants. This is what I'm saying. Do you have a history of arresting people without warrants or evidence, sir? This is the question.
I'm gonna object because
If
he's
so,
not,
Let him finish the objection.
he's already, the witness has already testified that he did not arrest him.
Or have a warrant at the time.
well, what I was, Judge, what I'm trying to establish.
You're trying to establish way more than
Well,
what's needed for this exam.
well,
This
what-
is a whole, holistic type of approach you're trying to have here with the police department, Jim Worthy, the bench, I understand that, but as far as this case, if
Right.
you're not getting to specifics about what he did, he's not even seem to be that involved into what
Well,
happened.
what I'm saying is that as right now, you had a chief judge that just heard my motion to deny me because they're your supervisor. He's the supervisor of these officers. If they move at his direction. If they don't move at his direction, that means they're vigilantes, Judge.
Oh my God.
They want
In
to
your
do.
opinion.
I mean,
So
it's-
what
So the judge already told him that if he has an issue with the manner of which he was arrested, then he can file a motion to that. This is simply a probable cause hearing, though.
the next question?
well, my question is
Him trying to cast aspersions on the police department is ultimately not really relevant here, because again, the supervisor didn't arrest him himself.
We have a history of arresting and charging innocent citizens without warrants and without evidence. And
I would object to the form of the question.
Okay, now to establish that he's telling the truth, I would like to file a motion for the discovery under MCR 6.201, which allows this to his background history of complaints for false arrests or things of that nature. And I have transcripts before where this has already been proved in other court proceedings. And I would like to, at this juncture, subpoena his background history as to Warren as well as to Detroit, because if he has done this today to me, he has done this to many other individuals. And I would like the procedural and the substantive due process protection in this proceeding and the equal protection of the law of the 14th Amendment. Judge.
I'm denying that request. I know you like to object. Please object so we can move on.
Judge, I mean, okay, now, like I already placed my objection, I'm being denied my rights to a fair trial.
It's not a trial. That's
I mean, not my trial. Well, this is a hearing. What I feel entitled to my rights in a hearing.
Cause hearing. It's not guaranteed by the Constitution. It's a statutory right.
Well, if there's a federal right, we have two different opinions, all respect to the court.
And I'm sure mine is right when it comes to whether or not you have a constitutional right to an exam and whether it's statutory.
Okay. All right, I'm ready with my question. Okay, so are you familiar with the law in Michigan so far as state statutes, state laws, and things of that nature? Do you have some form of
Oh my God.
some form of legal training when it concerns your job? You went to the academy back in the day.
Yes.
Okay. Did you know under MCL 750.505 this kind of offers that is a 5-year felony that you have committed against me, sir, based on lack of evidence and no warrant, sir?
I'm gonna object.
Well, the objection is not founded, Mr. Prosecutor.
Let us have his, what is it? I don't even know what objection is.
Relevancy, defendant's testifying, he's accusing of crimes,
Argumentative.
argumentative.
I know.
So the question just doesn't make sense.
Can I respond, please?
Argumentative. All
All of them. And then, like I was stating, Kwame Kilpatrick was sent to prison for the same thing that he's doing. And I mean, he was the
Now,
mayor.
You're not about to convince
Okay.
me of anything,
Yes, ma'am.
mentioning Kwame Kilpatrick's conviction, so.
All right. Well, I mean, can he answer my question? I mean, if he's a law enforcement officer, he should have no problem answering questions. of
Well,
the
it's
law.
not relevant.
Well, it's relevant because he's committed a felony, Judge.
That's an accusation. It
It's-
has not been presented to the court in any matter other than you telling him that he committed.
Well, can I again ask this court on the MCR 6.201 Brady versus Maryland, request his background history for purposes of impeachment at People versus Stanaway, which allows.
More discovery?
Yes, I would like to have more discovery so far as impeaching his witness,
So,
because
Mr. McCreary, if this is found over, I will sign the discovery order.
well, I'm just saying is I need it for purposes of the exam under MCR 6.110 to properly cross
Discovery is
examine.
an ongoing, it's ongoing.
Well,
So today, the exam, we're in the middle of it. There's definitely a time to prepare for this day. If it gets found over, I will sign a discovery order, and you can request.
well,
Okay?
yes, ma'am. Under People versus State, again, I say that citation I would have today here in court with Judge Rhodes to dismiss a case against the prosecutor as a sanction for withholding evidence. He knew that his witnesses would be here, then he didn't.
Very, that's an argument that you can discuss during the argument once you're.
So he's not allowed to answer the question that I asked him so far.
No,
So,
I'm just saying.
okay. Are you familiar with Mr. McCurry or your department, the 10th precinct at all? Have you ever had any knowledge of him coming to your department or complaining about your department or anything to that nature?
For this case, I never had any contact with him.
Okay, are you familiar with the Sergeant Ball that worked at your organization?
Yes.
Okay,
Wait 1 second, sir. Is it the one that's retired or the sergeant?
He's retired.
Okay, because there's two balls there, two sergeants at some point. I just want to make sure I have the right one.
yes.
Okay.
Okay, so you did your investigation. How did you come about knowledge of Mr. McCurry beside with his brother? How did you know how Mr. McCurry looked? What information did you find out where he lived? Did you do a lean check? Did you check the system for pictures?
Oh my God, padding, he's padding all these questions. Why are you not objecting?
Addresses? Did you do any of that, sir?
So typically when I get a case, it pops up. We call it our hopper. It's where it lists all of our cases we got for the day. I make my initial calls, try to make contact with victims, get them in for another written statement because sometimes we get a police run. People's minds are elsewhere. Or, they don't ask the right question, I might need more for my investigation. Or let's give them to come in, either me or someone else who might be you. Get a written statement from them so I can more of the story. That way, once I do send something like this over, whatever I get, I can put on paper and I send it over to the prosecutor. If they think there's probable cause to go forward, and then a magistrate thinks that, then it gets signed. If they don't, then I can only present what facts I have.
Okay. At your precinct, you guys have a warrant prosecutor?
A warrant prosecutor?
Yes. Typically, I remember from back in the day, you know, like they have assistant prosecutors available so that they can sign off and stuff like that. And that's relevant. He's positive.
And also,
More testimony.
I'm gonna check the notes here.
Other than you establishing in your argument that there was no warrant signed, what is your purpose?
I'm trying to show how his investigation came forward. Like, I mean, like, I know I've read things in certain Fourth Amendment. Fruits gathered after an illegal search and seizure are invested in court. And I'm trying to establish that. I remember from back in the day that they had prosecutors readily available that could sign off on stuff like that. The prosecutor didn't sign off on it. And I'm just trying to.
I'm sustaining the objection. It's not relevant right now. You can put that in a motion if it gets filed over.
Are you aware that Mr. McCreary, past and present, has come into your precinct, made complaints against your officer there?
Your brother Norman?
No, me, Colonel Michael McCreary. Ill.
I'm gonna check.
Oh, not relevant.
It's for purposes of impeachment, Judge. That's how it's
Everything you keep
relevant.
saying is for impeachment.
People versus Stanaway.
Yeah,
Stanaway laws.
it does not say you can impeach on anything. I know that case law does not say that. You can say anything if it's impeachment. That's not how impeachment works.
Well, I'm trying to show and establish retaliation by DP.
Okay.
Because of numerous complaints against them, because of recording them, putting them on YouTube, where they told the officers to break in the house.
On the stand, doesn't know your brother, Gary, until this case is filed, and doesn't know you. So can we move on to something else about what happened on the date and time of the investigation regarding you and your brother's complaint?
I mean, yeah, I objected again to this court's handling of this case. I had something in mind which you proved y'all to. This gentleman here. Okay. Did you ever look at Mr. McCreary's picture? It was stated in here that you showed, or one of your officers showed Mr. McCreary, my brother Norman McCreary, picture. Is that correct?
Correct.
Do you know what picture it is? Do you have a copy of that picture here today in court? Because that wasn't in discovery.
It's included in my packet. It's an over the APA's office. It's the Michigan SOS picture provided to me by the law enforcement information that we call link.
And what came up in the link? My driver's license, or what came up?
The Michigan SOS picture, yes.
Okay. All right. Your Honor, can I have the court officer show the prosecution's witness something?
Your Honor.
It's your witness.
No, I have.
What is it? I don't even know what you're trying to do.
I'm laying the foundation. He's keep trying to shoot
What are
me
you
down.
trying to do?
I mean, I'm trying to figure out how he came in contact with me, how he came about. He just stated it.
Anonymous, thank you for the $4.20. For the $4.20 tip. I give up. I can't. These headphones are killing me. I'm gonna. All right, I'm just gonna move some more money around, and I'm gonna move some money. I'm just gonna go dip into my savings because I need to move some money around, and hopefully I'll get some Amazon points and I'm gonna get a new pair of headphones this weekend because these things are killing me. If you guys don't know what happened, is that this ear is like bent like this. It's not supposed to bend like this. So when I have the headphones on, like, you see how it, you see how it bends like this? It's like crushing on my ear, and it's the most uncomfortable thing ever. It's like, oh my God, it's irritating. I can't take it apart. There's no screw. There's no screws to open this damn thing up. Oh my God. All right. Anyway, moving on.
Here, so I'm going to show my driver's license.
I need to get these wireless versions.
Did you ever look at Mr. McCreary?
It was like this. That's why.
Did you ever look
That's why if you guys have noticed, I've been holding on. I've been pushing the ear like this to make it comfortable.
at Mr. McCreary's driver's license?
His actual license? No.
Which Mr. McCreary are we
Me, I'm talking
about?
about me when I addressed me. Well, Cornell McCreary. Did you ever look at Cornell McCreary's driver's license when you did the investigation?
Physical license, the one that's in your wallet? No.
Okay, but what I'm saying is in the system,
It wouldn't be your license, it would be the picture provided by Lee.
the picture by Lane. Oh, okay. Lane system. I didn't. Okay, so I believe on the paper.
Not e-begging. I could get these myself. Thank you.
CTN?
A CTN, like on judgments, warrants, things of that nature. It said CTN, then it has ORI.
You asking me what a CTN is?
Yes.
So that's gonna be generated by the system.
No, I'm saying you give me a breakdown and define what CTN.
It's not something I deal with on my end.
Josh, I probably dropped these one too many times.
Attorney, since he always wants to object, could you tell me what a CTN means, sir? And help you with it?
I'm not testifying.
Okay. So you don't know what a CTN. Did you know that a CTN is?
I don't have objective relevancy.
I haven't finished.
I don't see the relevancy of the CTN.
I'm just saying is I haven't finished my line of questioning. for him
Well,
to
I
object.
can't imagine what a CTN has to do.
Well, it's a
Assault
cargo
with
tracking
intent to
note.
murder. I'm sorry, what?
It's a cargo tracking note.
Okay, and that's not relevant today. So next question, I know you objected to that as well. You placed on the record,
So-
Mr. objection to my.
Epoxy grill? I don't know what that is.
You stated that you looked at my ID and whatever else in the link said.
Right.
Okay. Did you know, that me, Colonel Michael McCreary, reserved his rights not to be, governed or controlled by city, county, state, federal officials? Well, I mean, it's relevancy. I tried to establish
It's
relevancy.
relevant to you, Mr. McCreary, but it's not relevant to the case here.
Well, it's relevant because I'm not the strong judge. I'm not
Okay.
doing business with the corporation. This is what I've been trying to
And you
establish, but
have-
you're limiting my
I am.
defense. My
I am.
defense, Judge.
I am.
What about the motion so far as additional discovery to impeach him for?
What did I say?
I'm not gonna help him.
What did I say?
And I have those
What
rights.
did I say?
You said after the fact, it was bound over, you will sign a discovery order, but I'm entitled to that to do a proper defense.
That's what I said. That's not gonna change.
Well, under federal law, I have a right to present a defense, and this court is denied. So I-
Oh my God.
You've been here for an hour. You've been presenting things to us.
Okay, I mean, I can't question this guy because, this officer, because the court and the prosecutor keeps objecting, I'm being denied the right.
Well, maybe because you're not that great at
I mean,
cross-examining.
I'm very well, I mean, I have a right
You're not
to,
that well versed with the court rules or evidence.
well, I fight with constitutional law, which you have ignored, which you have.
Definitely fight with it.
Well, I'm just saying, under the
But-
Constitution, this court is bound.
Okay, now, okay, seriously, contempt. Like, he's been beyond disrespectful to the judge. Contempt.
I know what I'm about. Do you have any other questions?
I mean, I'm being denied, so I would just object, and then I would, once, if it's bound over, I would do a motion for a remand back to this court in front of the circuit court with paperwork. And, you know, like I said, I'm in the process, I should be taking that down in this coming week to the federal court. And I would like also to have this case removed to the federal court.
Do you have any more questions of the witness?
I mean, I can't question
Yes
them.
or no?
No, I can't because I'm
Okay.
being denied.
Okay, any cross? No, Your Honor. Okay.
Thank you, Your Honor.
Theodoric 93, thank you for the $10. You're a saint. How are we still sitting here listening to this person talking? Honestly, when I clicked on this video, I was planning on watching this video with you guys today. I did not. I guess I misread the time. I did not realize that this damn thing was an hour and 30 minutes long. I'm so sorry, guys.
Yes, I would like to call the other witnesses listed on the paperwork.
And what did I say about that?
And you denied it.
I said you.
I honestly thought it was like 40. I thought it was like.
Available for you to interview them.
I missed the hour. Okay, I missed the hour part. I think I only saw it was like 34 minutes. I missed that it was an hour and 34 minutes.
So they're not here. So you're not here to call them.
Well, can I just want to say this for the record, so just in case the higher court looks down the line at this.
Sure.
And like I tried to explain to the court, it was my intention based on the reading of the rule in the case law. It says even where you cannot show actual bias in Michigan Supreme Court, that you would be removed and then I would have time to prepare these motions and documents. And I'm being railroaded by this court as well as the people who just admitted they have no warrants, they had no evidence. I mean,
The
what
higher
is?
The higher court, that's what, I'm at the district court level, so that's what higher courts are for, so they can address.
But is okay, but may I respond to say something? Now, the law is clear. I mean, you took an oath under Article 6, Section 2.
Mr. McCreary, I don't want to hear about it unless it's about your argument in response to people arresting after they arrest. Well, actually, they arrested already. And you don't have any other witnesses present.
Well, I mean, I'm denying my witnesses.
You never
And
denied.
evidence.
You never submitted a witness list. You weren't being denied everything.
You had a witness list, you can contact, you can ask the prosecutors to provide
I
them,
didn't think
or
this-
make them available for you to interview, or contact them, or subpoena them to come to them. This has been adjourned several times. That's plenty of time to do so. I've let you go to the library to research. I've let you even go to the court to file a lien against my house.
No, I'm waiting.
I've done way more than I should have allowed you to do. So I am not going to adjourn this or provide a discovery request to you or grant that based off of you not being prepared today to call witnesses that were provided to you on the witness list. So are there any other witnesses present today that you would like to call?
Well, I would like to respond if I may.
Yes or no?
Because you say I can't because I'm being denied.
Okay, so you don't have any other witnesses?
I mean, I have them. Yes, my brother Charles McCreary. I would like these police officers to be brought into court. Robert Vane, Diana Gerald. I have many other people that are.
Yeah, I think I heard that too. I think he did. I think the judge did say that he tried to put a lien on her house, which is a classic sovereign citizen tactic.
To come into court and testify, and I'm being denied that. And I would like to just again to clarify for the record that I didn't think that you would be moving forward because I was just in a court proceeding with Judge what's her name, where she denied the motion, then she sent it to the chief judge. Because from my understanding that if the judge grants it or denies it, then they have to send it to the chief judge. You never ruled granting or denying the motion per the court rule.
You accused me of being biased, so why would I make a
I
decision?
mean, well, what I'm saying is you.
Why would I
could
make a
withdraw-
decision on
What I'm
something
saying so
where
far.
you're saying that I'm biased to you?
Well, I'm about to answer this. Like if you would have said denied, then you had to send it to the chief judge. If you would have granted it, okay, it would have been sent for a blind draw. Per the rules and under people versus
This is blind draw, this is not trial. This is the exam stage,
I understand.
okay? So you don't have any further witnesses.
Why do
Today was an exam,
I mean, I wanted them at the
they're
exam.
just not here.
But they're not here.
Subpoena them, ask them to come, or ask the prosecutor to make them available. So I'll be in.
Thank you, Your Honor. Your Honor, people move, bind over the defendant on all charges. It's a matter of, it's a question of fact. We have one witness, that says that the defendant took shots at him, put him in fear for his life. Defendant is a felon, convicted felon, and therefore he's not allowed to have firearms or ammunition. He attacked his own brother with bricks and a rifle. And there has been no official testimony of him not doing it, other than the defendant during his objections or arguments or whatever they are, saying that I didn't commit a crime. It's a question of fact. It should be found over. And testimony was that it occurred in the city of Detroit, County of Wayne, so this court definitely has the jurisdiction under the court rules and the law to hear this and bind this over. And you know, he took aim at his own brother and shot at him. So we asked for a bind over on all charges.
First and foremost, I would like to object because by the officer on admission and the prosecutor knows fully well, there's no evidence, Judge. Not just that. The witness lied here in court today, and he's not credible. He stated that he never forged any signatures or whatever else. And I have evidence to show the opposite, that he committed perjury right here on the stand.
He's still going.
The burden is on the prosecutor. I'm innocent until proven guilty per administration of justice.
We're not at trial. This is a probable cause hearing.
Again, I adamantly object and deny these allegations. He's stating that ammunition, all that. Where's the pictures of the guns, Judge? Like I stated before, where's the evidence at? Except my brother, who has lied in the past, and he has a dishonest history, and he has a history of theft. And let me finish. I didn't object to. I didn't interrupt him. I'm giving my code. I didn't interrupt him.
I'm just gonna object.
Just objecting.
That's fine. I didn't say that when he was talking.
We've been talking all day.
True. He has been talking all day.
Facts that you try to get into evidence and they're not in it.
Mr. Walkie, I know this.
Okay.
Objection on the record. Mr. Secretary.
Okay. Under Opera versus United States, 348 U.S. 84, the Supreme Court held an accused extrajudicial admissions of essential facts or elements of the crime made subsequent to the crime are of the same character as confessions and cooperation by independent evidence is required. A, the requirement of cooperation applies to exculpatory statements to the same extent that it applies to incriminatory statements. The jury's finding in this case from the admissions of the essential facts together with all other evidence that the guilt of the petitioner had been established beyond a reasonable doubt is supported by substantial evidence.
Beyond a reasonable doubt is at the trial.
Okay, and I'm just reading this like.
I'm trying to say. He's so stupid. He's so stupid.
To prove that the corroborative evidence need not be sufficient independent of the statements to establish the corpus delicti. It is sufficient.
Corpus delicti. Mark that on your bingo cards.
If the cooperation supports the essential facts admitted sufficiently to justify a jury inference of their truth, but those facts plus the other evidence must be sufficient to find guilt beyond a reasonable doubt. Now, I understand that this is just probable cause, but why waste the state's money and continue this vindictive prosecution to proceed, Your Honor? They've admitted that they have no evidence. They've admitted that they have nothing but this man's word of mouth.
The man's word is evidence. The issue is whether or not the evidence is credible. Which you try to impeach your brother's credibility, but you failed miserably.
Who is in the community is known as a liar and a perjurer. And I wanted to call Chief Judge Burton, who's in Wayne County 3rd Circuit Court, to establish this. That he lied under oath, that he committed felonies. I mean, the prosecutor's office committed felonies, their witnesses committed felonies. I mean, it's factual. So at this juncture.
You can all of that at the trial, at the 3rd Circuit.
Well, again, I would like to object to this court's hearing of this exam for judicial bias because under Kane versus MPOC, it says that even if I can show bias, justice teaches that the judge should recuse themselves because you have been the target of criticism and so on and so forth.
Only by you.
Okay, but what I'm saying is, and I've been
You've been the target of criticism, Judge. So your credibility is questioned. You're the only one who's been challenging.
And the court overruled federal law, which state law.
It's bad law.
Okay, well, I've researched it. And standardized it, and it's still good law.
Okay. So,
Archer's doing good. He needs to eat, though. I need to make sure he's eating.
Mr. McCurry, you have major argument rejected for the record. And would like to preserve that argument that there's no evidence presented today. What the court has to remind sense of is that testimony is evidence, whether you like it or not. I do believe that witness, Mr. Norman McCrary, was credible. And the burden of proof is on the people. And they have to show at the probable cause standard. First, assault with intent to murder, that the defendant tried to physically injure a person, another person. There's testimony that the defendant, Mr. McCrary, tried to by not only aiming but also firing a gun at the complaining witness. Second, that when the defendant committed that assault, he had the ability to cause injury. In this case, he did have the ability. That was a deadly weapon that would definitely cause injury. And third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or produce the crime. That would be a question of fact for the trier of fact as to the intent and what Mr. McCrary was doing. Pointing the gun, I do believe in the probable cause standard, pointing the gun and shooting someone shows intent to kill. As far as the remaining charges, assault with intent to rape by the harm less than murder is lesser included, satisfied by the evidence testimony. The count
Okay, so there are no actual SA charges. I don't know. I could have sworn there was. They mentioned it.
not eligible to the possession
Huh.
of
Never mind.
firearm.
So this is all about him almost killing, him allegedly trying to kill his brother.
Satisfies count 4, ammunition possession by a felon, and count 5, assault with dangerous weapon, felonious assault, has been satisfied based on the same testimony from the complaining witness and of course the 4 accompanying weapons, assault firearm charges. So, Mr. McCrary, you're going to be bound over to Third Circuit Court, Framework of Criminal Justice, for your arraignment information date of June 29th at 9:00 a.m. I do not know if it'll be on Zoom or if it'll be in person. It depends on which judge you draw. Anything else from either party?
No, nothing from the people, Your Honor.
Mr. McCrary, other than your objections?
I would like to place my objections on the record because throughout this entire proceeding, I feel that this court has been biased when it comes to rulings. They've even allowed this prosecutor to use state law to supersede federal law, as stated in Cohen's versus Virginia. Considered treason against the United States Constitution. These are landmark cases, and
Yeah, in Virginia, thank you for the 199 super chat. Buy a couple of bottles of rose for Archer and Winston. Thank you very much, Cat.
Under standard due process, the U.S. Supreme Court held that no matter what rules you create, you must use fundamental fairness.
McCrary, you've already been presented.
Well, I mean, you asked me to have anything else to say.
Anything else? Anything additional?
Well, I object. I mean, I'll just let you buy me over.
We already know. We already know you object. We don't care.
I challenge jurisdiction before testimony.
Oh, Jesus. He's trying to challenge jurisdiction again.
But the law
Do you want the
mandated.
discovery order signed? Before I buy you over? Okay, what was it specifically that you
I
wanted?
mean, I would like all the officers, background history.
All right, we're done.
I would like.
I done. I can't. I can't do this anymore. There's like 4 minutes left, and I can't do it. I can't. Oh, what is this from Van Balian? Oh no.
If you don't step out, you're gonna get maced, okay? Hey, sir, you know what? If you mace me, I am not giving you guys any trouble whatsoever. Look out, Mike. Look out, Mike. Hey, I'm not giving you guys any trouble whatsoever.
Uh-oh. Uh-oh.
Welcome back to the Van Balian channel, guys. Today we head to Cross Lake, Minnesota for a traffic stop where a softseat gets pulled over for speeding and actually complies with the law. That is until the cop smells a strong aroma coming from his truck.
Uh-oh.
That's when the pseudo-legal nonsense begins, so the cop calls for backup and let's just say things don't end well for our softseat friend. Right, let's get into the video.
Hello. Good, yourself? Not bad.
You know what? If only he had just waited one more year, because Minnesota just legalized marijuana. So if only he waited just one more year. then you wouldn't be in this situation.
The reason why I stopped is for speeding. You're going 65 miles an hour. The speed limit is 55. I looked down there. What's that? I pulled over at 50 and pulled over. So. Yeah, I was going to talk to you about that too. We prefer as law enforcement not for you to pull over until we signal you with the lights, because people pull over in really bad spots sometimes, and you know, I wasn't getting your license plate back because this obstructed a little bit of snow that stuck to the front of it. So I ran that when I called out the dispatch, wrong one came back. So that gives me time to see if, you know, who I'm stopping or if this vehicle is associated with something not good. Yeah. So 94 to 9423 for the. That back. All right. Is the Mike? Yes. All right.
Yeah, I know what you're all thinking. Are we in the Twilight Zone or something?
Right?
Because it's weird to watch a song.
Seriously, Van Balen, what is this? I'm feeling like this is a bait and switch. This is clickbait. So far, he's given them his license, registration, and insurance card. What is happening here?
Offset complies so easily with law enforcement, but it's not when you understand their skewed logic. He complied because he says he's working, so in his mind, he's operating in commerce.
Ah, gotcha. Ah, okay. There it is. Okay, so now, because he's working, he's acting in commerce, and therefore statutes and codes apply to him.
He undermines this argument later on in the video, of course, but for now, that's his logic. Anyway, this is where the cop smells all the weed, and when you know how much weed he has in the truck, in individual plastic bags, I might add, it's amazing.
Well, that's... So that's like not just possession, but that's painfully obvious possession with intent. When you have it in individualized baggies, that's like clear evidence of intent.
Amazing how he thought he was ever going to get away with it. But again, soft sit logic.
Can you do me a favor, step out for me, please? For what? Because I'm going to search your vehicle. I can smell marijuana coming from it. No, you have to supervisor, I'll get these. You see these? Yeah. I'm the supervisor. Okay. 303-100. Give me another car, please.
Supervisor.
Yeah, I don't need you to get set. Yes, I do. Yes, you do. Yes, you do. I'm not gonna ask. What's your RAS? Okay, I'm not gonna ask you again.
What's your R? He just asked, what's your RAS?
Excuse me? What's your RAS? Do you even know what you're talking about? Yes. No, you don't. Step out of the vehicle for me, please.
Uh-oh.
I refuse to step out. Because you know why, sir? You have no right to take me out of my vehicle for a traffic stop.
Sorry, dude, but like...
Pen v. Mims!
What you're talking about. If he can smell and then go on to find a load of weed in your truck...
Pen v. Mims, baby.
Then yes, that absolutely does give him probable cause to search your truck without violating your Fourth Amendment rights. This, people, is a classic case of someone who has been listening to the wrong people on YouTube.
I can smell marijuana in your vehicle, and that is... my car. Yes, I can. No, you can't. And that is probable cause to search a truck. It is not probable cause. Okay, this is going to go one of two ways, and you need to understand this. It's going to be more than one or two ways, sir. No, you're going to get more cars out here because you are violating my constitutional rights. This is what's going to happen. You are violating my constitutional rights. Keep your hands where I can see them. Yep, I'm just going to get my video out. That's all. This is what's going to happen. I'm just going to videotape.
Oh my God, he's got that Minnesota accent.
And that's all there is to that.
So not only do you not understand your constitutional rights, you think reaching around in your truck is a good idea. How people like this make it to adulthood is a mystery to me.
Because I am not doing this, I'll tell you what. Are you listening to me? This is what's going to happen. Okay, you're gonna comply. You're gonna comply with what I ask you to do, or you're gonna go to jail for obstructing. Okay? There is no obstruction of secondary crime, sir. You're violating my constitutional rights. No, I'm not. You have no idea what your constitutional rights are. I have no cause for you, dude. Okay, you are violating my constitutional rights right now. You are violating my constitutional rights. What's my closest car? You are violating my constitutional rights. I've done nothing wrong. There's no reasonable suspicion of a crime has been committed. And that's that. You have no reason to ask me to get out of my car. I have a valid driver's license, valid insurance. And what is your reason, sir?
Okay, the reason for the stop was your speeding, which you admitted you were doing, okay?
I didn't admit to anything.
Well, you told me you realized. Okay. That's the reason for the stop, okay?
You didn't stop me. I was out on the side of the road, sir.
I stopped you because you're speeding.
I was sitting on the side of the road with my hazards on, sir.
Okay.
Amazing logic.
So basically, I stopped first. Ergo, your traffic stop is null and void. That's not how that works. I circumvented the traffic stop by stopping first.
Pulled over before the cop officially pulled him over with his blue lights invalidates the stop. Just incredible.
Well, there's going to be another car that's going to come here, and then we're going to remove you from the vehicle, okay? So you can either step out willingly and cooperate with me, or it's going to go a completely different way, all right?
Go a completely different way because that's against my constitutional rights.
Okay. Keep your hands up on the steering wheel. Keep your other hand on the steering wheel where I can see it.
My hands are clear. I'm not any threat to you, sir.
Put both your hands on the steering wheel.
Okay. But you are violating my constitutional rights. I have a valid driver's license, valid insurance. You have no probable cause to get me out of the vehicle for any reason whatsoever. So.
Except he just gave you the reason. Whether you think it's valid or not is right now irrelevant. The place to make that argument is in court, not at the side of the road. But these fools will never learn that.
No reason whatsoever. What is your RAS? What's your reasonable?
I'm way past RAS.
Where's your facts then?
I'm way past reasonable articulable suspicion.
Where's your facts,
I am to the point of probable cause.
You do not have probable cause.
I can smell marijuana in your vehicle, and that is probable cause to search your vehicle.
Marijuana, sir. Okay. That's how you guys come into cars for unlawful searches and seizures, sir.
Right. Well,
and persons of seizures. I consent to no purchase or personal searches whatsoever.
Well, I'm not asking for your consent.
You have to have my consent.
No, I don't.
Yes, you do.
No, I do not.
You do have to have my consent.
Okay. No, I don't. I'm not going to argue with you about it, okay?
You too, sir. You have to have my consent to search my vehicle.
Okay.
Okay?
Not if the officer has probable cause. Now afterwards, if you move a motion to dismiss or motion to strike, because you feel that the officer didn't have probable cause, you can make that motion, right? And if the court agrees, saying, okay, from what we have from the officer's testimony, from the police report or body cam footage, whatever, no, there wasn't enough probable cause to search, then the evidence is stricken and the case is dismissed, or most likely going to be dismissed because they don't have any evidence. But that's usually an after the fact thing.
You have to. You're not coming in here. There's nothing in here anyway, but you're not coming in here. So that's that.
Well, that sounds like a challenge to me, and just in time for when backup arrives as well. Also, he doesn't need your consent when he can smell that you have a crap ton of weed in the truck.
Get a warrant.
I'm not getting a warrant. I'm going to search your vehicle.
You can't get a warrant. You don't have no right to search my vehicle.
Okay.
You have no right.
You on probation, Mike?
Nope.
You're not? So what's in the vehicle that you won't allow me, that you don't want me to come in, or you're not going to cooperate?
Destroyed by tyrants, okay?
What's that?
My home was destroyed by tyrants, so I'm not allowed to enter.
Well, your home had a bunch of drugs in it, that's for sure.
It didn't have any in it.
Wait. Oh, whoa, wait. Do they know each other? Do they know each other? No. Oh no! My home was destroyed by tyrants. There was a shit ton of drugs in there.
Okay. So there you go. You guys are gonna be paying millions for this one. Millions on this one.
Okay, well then you might as well just cooperate and step out, because my head's getting cold, my hands are getting cold, and
out of my vehicle, I can send
okay.
Well, all I can say is this must be some really good weed if he thinks this stop is going to net him $1 million.
Well, I'm not asking for your consent. I'm ordering you out of the vehicle, okay? So what's going to happen when another officer gets here?
That same thing.
So tell me what's going to happen when another officer gets here.
Out of my vehicle.
Okay.
Tell me what crime I've committed.
Okay, you were speeding.
Okay, so you write me a ticket.
No. And then when I come up to your vehicle, my problem cause to search your vehicle.
Akira, thank you for the super chat. I think I missed you. Sorry about that. But thank you for the super chat, Akira.
That's what everybody says. Order marijuana. Everybody's car smells like marijuana.
Do you realize when you smoke
For the $4.99.
marijuana in your vehicle, it smells like marijuana? Do you realize that?
I haven't smoked marijuana,
Okay.
sir.
Regardless, that's what I'm doing. So I'm asking you, what's going to happen when another officer gets here?
Nothing.
I'm going to ask you to get out of the vehicle.
You're not.
303, what are you going to need more than one car? Probably two.
I refuse to any searches and seizures, sir. We are live too. Okay, so you have no right to ask me to get out of my vehicle, and I've done nothing wrong.
Okay.
Over a simple
Obviously, you
traffic
don't know it.
I have the right to travel as it is.
Obviously, you
don't. There it is.
One of those now.
Yeah.
And he said, "Oh, you're one of those now." So he does know this guy previously, and he's like, "Oh, so you do. So you're right to travel. You're soft sit now, huh?"
So what's this then?
That's when I'm in commerce, sir.
Huh?
That's when I'm in commerce. I have that.
So after listening to him butcher the Fourth Amendment,
oh no!
Surprised that he doesn't understand the right to travel.
Hmm.
I never was, but now I am because I see the entirety going on in the world today. You know what? You're not violating any of my constitutional rights.
No, I'm not going to. I'm gonna do what I am allowed to do by law. Okay?
This is my property and my person, sir. So you have no right to come in my vehicle. I've done nothing wrong. You got no suspicion of crime has been committed, except for a simple traffic violation. And that's that. I gave you my information. I suggest Bryant. That's me. I'm legal. Let's both be on our day. That's that.
Right, so let's skip ahead to where backup arrives, because this is where the fun begins.
Hope everybody's getting this. These pirates are about to drag me out of my vehicle for no reason. I've been stopped for speeding. I've given the officer my driver's license and my...
Mr. Daly.
And...
Mr. Daly, listen.
Drug out of the car for no reason.
Listen to me. I'm going to ask, listen to me. Can you listen to me, please? Listen to me, please, okay? I'm going to ask you one more time to step out of your vehicle, okay? If you don't step out, we're going to remove you from your vehicle. Do you understand that?
From my vehicle, you will lose your qualified immunity, and I will sue you guys.
Do you understand that?
You understand me?
Are you going to get out and cooperate or not? Can you turn your truck off for me, please? Will you turn your truck off, please?
Oh boy.
My property.
Can you turn your truck off, please?
You have no right to search me, sir. You have no right to search me.
Can you turn your truck off, please?
You have no right to search me.
Okay. Step out of the vehicle, please.
No, sir. You have no right to search me.
If you don't step out, you're going to get maced, okay?
Hey, sir.
Uh-oh.
If you mace me, I am not giving you guys any trouble whatsoever.
Look out, Mike. Look out, Mike.
Hey, I'm not giving you guys any trouble whatsoever.
Uh-oh.
What?
Not giving you guys any trouble whatsoever, he says. Yeah, right. Says the guy who has done nothing but cause trouble by refusing every single lawful order to step out of his vehicle.
What the fuck, man? This is a violation, dude.
Get out of the
Look
car.
at this. Dude, are you a supervisor? Really?
I mean, yeah.
Oh, my God! Ow! 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 Put your hands behind your back. Ow! Ow! Fucking police brutality! Ow! Ow! Fuck, man! Ah! Ah! Help, people!
Screaming bloody murder.
Stop your whining and crying. You were given ample opportunity to step out of your vehicle peacefully. No, you just couldn't do it, could you? Well, this is your stupid prize for playing stupid games. Maybe next time, just comply with a lawful order. And what do you think shouting "help people" will achieve? Does he really expect to be saved by random people out in what looks like the middle of nowhere? Unbelievable.
Help, people! Out! Stand by.
My dick, dude! Ow! God damn it! Dude, what the fuck, man?
What the hell, man?
As you can see, the more you around, the more you're gonna find out.
Furious? My God! 15. What the fuck, man? I have no weapons, I have no...
Well, you also said you didn't have any weed in the truck, and just look what happened there. So I don't think they'll be taking your word on anything right now, somehow.
Throw him over. Towards you guys. Look at this.
Well, they didn't know he had weed until after the fact. I mean, they smelled it. I'm being nitpicky, but yeah, they don't. Regardless of whether or not he was lying about the weed that they find out after the fact, they're not gonna take your word for it.
Fucking bleeding and shit? You guys are something else, man. Shut up. Holy fucking shit, dude. You guys are fucking all going down for fucking police brutality.
Come on.
Holy shit, man. Fuck you, dude. I don't have any weapons, man. I don't. I don't have no weapons.
Tuck your foot up.
What
here.
the fuck?
Tuck your foot up. Tuck your foot up. We're gonna stand you up. Ready? 1, 2, 3.
I fucking told you guys, man. What the fuck, dude?
Listen to me, Michael. You're under arrest.
Fuck, for what? For what should I do?
Calm down. Calm down.
What have I done? Stop searching me. I'm not.
Right now you're under arrest for obstruction, okay?
Fuck you guys, man. You guys fucking fucked me up for no fucking reason, dude. You guys
Calm
are fucking
down.
Fuck. What the fuck, dude? Fuck you guys. No, you guys can fucking kiss my fucking ass, man. You're fucking all getting fucking sued, dude. Fucking police brutality, fucking all this shit. Anybody seeing this shit, you guys? This is what happens when police overstep their bounds.
Nobody here to hear you. Just
Come see the violence inherent in the system.
Please overstep their bounds.
Help! Help! I'm being repressed.
What happens when people learn their rights from the internet?
I do not consent to any fucking search, dude.
Duly noted, Mr. Daly.
Okay, good. None of this shit's gonna hand up in court. You're gonna get fucking sued, dude. Okay. Going where? Huh? It's fucking something else, dude. Fucking take me out of my car for fucking speeding. Fucking put me on the ground for police brutality. Fucking beat the shit out of me on a fucking traffic stop. Are you fucking serious? You guys are
You wouldn't get.
all of ya.
You wouldn't get out of the car.
You're fucking no, dude.
Oh God, Sean, what are we waiting for? No spoilers.
That's where I'm going to leave this one, but if you would like to watch the part where they allegedly find $100 worth of meth, quite a few bags of weed in individual bags, which explains a lot, I guess, and of course they tow his truck, then a link to that and the original video will be in the description. Right, thanks for watching, guys. If you enjoyed the video, then please leave me a like, share the video, and subscribe to the channel. Thank you also to my channel members and patrons for your continued support.
Well, I was not expecting meth.
Right, take care all, and I will catch you in the next video. Welcome back to...
All right, we did not see the mace. The mace was threatened. But this one apparently has mace. I haven't seen this one either. But this one is from Arkansas State Police. So automatically you know it's going to be like a 10-minute police chase before we get anywhere.
To the Van Balian channel, guys. Today we head to Knoxville, a city in Johnson County, Arkansas, where a state trooper pulls over a speeding motorist, who turns out to be a sovereign citizen. So he of course refuses to provide his details. The trooper calls for backup, and the rest, they say, is history.
Oh.
Right, let's get into the video.
Okay, I'm actually shocked that this doesn't involve a police chase. Yeah, I have not seen this yet. I just assumed there was a police chase involved. In the great state of Arkansas. Apparently, Arkansas State Police been hiring chipmunks. Diversifying.
Yes, sir. Hello, Corporal Crab with the State Police. I was stopping you for speeding this afternoon. May I see your license and insurance?
The Sheriff's Department has my driver's license.
Okay.
They've stolen on 2 different occasions, but I got the paperwork for you.
Okay.
Oh, so the sheriff stole your license.
The sheriff. Damn it, man! You're beating me to it.
Receipt for it both times. Well, that was nice of him. Surely it can't be because your license is revoked or anything, can it?
All right, hold on. Let's go to the original video. No, don't get me wrong. I'm hitting the like. I'm hitting the like and the like to. Oh, but he has it edited. I'm hitting the like to. Oh, there's no way. The raw video is like over an hour. Oh God.
Welcome back to the.
But he's beating me. He's beating me to all the commentary. I feel bad. Clipping the shit. Whatever.
They haven't replaced it yet.
Okay.
And my notice of liability.
Oh no. Oh no. So number one, we already see his window's only down about 2 inches. And number two, he's handing him what looks like is a bunch of paperwork.
All right. Give me just a second, sir.
Oh, there it is.
Yep, can't think why a person handing over a meaningless document such as a notice of liability on a traffic stop would have his license taken away. And it sounds like this trooper agrees because he immediately calls for backup knowing he's dealing with a soft sit. Apparently this guy has threatened judges and public officials in the past, and surprise, surprise, he has a warrant. So yeah, the trooper does the right thing and calls for backup before he attempts to make the arrest.
Uh-oh.
Now I've got a sovereign down here. It's gonna have somebody come over here.
I got a sovereign.
Come your way. 28 close.
J28.
I didn't hear. Do we have any warrants that will pick him up? Anybody want him?
I've sent a confirmation to Clarksville PD. I haven't heard back.
What's the warrant out of Clarksville PD for?
Shows original charge as criminal trespassing.
10-4.
Go ahead.
I sent confirmation to Clarksville PD. They advise the warrant is valid. They will not hold advised subject to go to the PD to get it taken care of.
16, you got charges?
Speeding and driving on suspended.
Okay, so it sounds like they say he's got a warrant out for criminal trespass, but they're not interested in holding him? Is that what that sounds like? But now the officer here says my charge or the allegation I'm putting against him is speeding and driving on a suspended license, because of course he is.
People posted bond. If you survive Clarksville, he'd be at the jail.
Okay, so all right, so they are going to take him in, and then they're just letting Clarksville know that they got him.
10-4, J28.
He's yakking to somebody on the phone. I'll just stand by until one of y'all gets here before you get him.
Oh, he's probably got a. All right, he probably has a guru on the phone right there.
Is this the one that was doing everything over in?
I'm not sure. He may have a weapon. I don't know.
Yeah.
He was fiddle farting around. Okay. Trying to stop me.
Yeah.
It kept her. Then all of a sudden I said, "He grabbed me." I got a boatload of papers. I could see crack the window that far. It's like, and I'm like, he said, Johnson County's got my license. They won't replace it. Well, I looked. I could see sovereign and stuff. I was like, I just somehow.
What do you want to do? You want to felony him out, or you want to?
Let's see if he'll come out. I don't know.
Okay.
If he'll come out.
He'll come out one way or the other.
He's coming out one way or another. He'll live farting around. He's coming out one way or another.
Music to my ears. Seriously though, this is why I love troopers from states like Arkansas. One is the accent, and two, they do not put up with this sovereign.
No, they don't. Arkansas does not mess around. If there's anything that I've seen from uploads in Arkansas, they don't mess around over there.
Yeah. There's Chad.
Okay, so they are, and we are seeing him. He's not just talking to somebody on the phone. He's like fidgeting around all over the place. And I think if they know that if they are aware that he's made alleged threats, then they're like, okay, we don't know if he's got a weapon or something. So they're obviously going to be far more on edge than normal. So.
Come here a minute, Mr. Markham.
What's he doing?
Mr. Markham.
Everything from the body language of the trooper is just telling me that he's like on edge. I mean, I know this is kind of, I feel like I'm stating the obvious. Everything the trooper's doing right here seems like he's got his hand to the ready. He's like kind of leaning in through to the front door, so he has the ability to like be able to dodge or something like that. So this trooper's like ready to go. He's ready. He seems like he's ready for anything.
He's talking to somebody saying,
is he answering you?
He's saying we're going to break his windows.
We will. Tell him that's going to happen. He's not wanting to get out. He's BSing around, saying he's talking to somebody.
Hey, step out. Step out over there. Okay, step out.
He's trying to hand him the phone so whoever he could talk to whoever's on the phone.
Step out. Open the door. Okay.
Yeah, all I heard there was I don't contract with you guys, which of course will always be a losing argument.
I think he said, did he say I have no contract with you? It's like, I also thought he said like, you're operating a corporation?
Because the law does not require you to contract or consent before it can be applied to you, which this guy is about to find out the hard way.
Open the door.
Watch out.
Open the door.
Watch out. He hits them brake lights, you jump.
Yeah, that's true. Like the officer just told her the female trooper is like, get back, and if obviously if we see the brake lights, that means he's ready to cut and run.
Stand over here.
Or that he's yeah.
Open the door. Open the door. Sir, you're operating it, okay? So open up.
He might take off.
I understand that you're driving on our highway. You have to have a license.
If we bust the window, we ought to spray him real quick before he can drive off. I got both.
Hey.
Or you could just place stop sticks under his wheels or block him in. On second thoughts, your suggestion is a lot more entertaining, so let's go with that.
True.
Yeah, do tell him that. If you don't open the door, we will bust the window. You're gonna get the wind busted. You're gonna come out. I'm trying to do this. You're operating.
God, I do wish we could hear what he said, what he's screaming at the trooper, and I really wish we could hear, we could figure out who he's talking to.
You know, it's kind of nice just watching a dashcam video like this sometimes because it gives us all a break from the usual magic words and incantations.
Now, see, I don't know. I want to hear
video.
I want to hear the words.
Kind of nice. Anyway,
no.
Lock him in to stop him driving away and give him another 5 minutes.
Okay.
So to...
Okay, thankfully, now they're doing the smart thing, but actually having a car block him to prevent him from leaving.
Out, even after being informed of his arrest. But he still refuses, so they go in for the arrest.
Y'all ready? Hey. Don't get behind that car. Don't get behind that car. We're spraying if we're... Hey, we're spraying if we're breaking. Get up.
Ooh, there it is.
I know. I know. Hey, watch his hands. Watch you ready? But he's been moving the whole time. Let's do it. Chad, let's go. Get on the ground! Get on the ground! Get on the ground! Get on the ground! Get out! Get on the ground! Get out of the car! Get on the ground! I didn't say nothing! Man, what the fuck are you doing at first? You better man, come on, man! Please! Get out of the car! I didn't do nothing! Get out of the car!
And the Oscar for Worst Actor goes to this guy for his performance in I Didn't Do Nothing, a double negative production showing here on YouTube right now.
Let me glove up.
What the fuck? I can't see!
Yeah, well, that's kind of the point of us.
That's usually what happens when you get a dousing of OC spray.
That's why you were sprayed with it. Still, you were warned.
I like how they're not even dragging him out, they're just letting him like scream and play along. They're just like standing there, like they're just letting him get it all out. Oh, they're just like standing there chill.
Go get your gloves on. Go get your gloves on.
Oh my God!
Let's go.
Help me!
Let's go.
Help me! Help me! Help me!
He's wedged in. He's wedged in.
Jesus Christ. Oh my God. You think they were like chopping his legs off. Oh my God. It's like a scream coming straight out of like fucking Saw.
Let go of it! Let go of it!
He's grabbing hold of the wheel.
Roll over.
It's part of me! It's part of me! Please get me out! Please get me out! The concrete's burning! All right, we'll get some just please, it's part of me! We'll get some.
He needs some milk.
I need something to drink.
And again, that's the OC spray doing its job. Bet you're wishing you'd gone with the easy option now, eh?
I can't see that. I can't see. I got you all about it burns.
We're 1015. Started EMPs for decontamination. One subject.
You're a loser. Are you feeling sorry for yourself? Well, you should be, because you are dirt. You make me sick, you big baby.
Great.
Hold your head up. Hold your head up. Water in the eye. We're going to get some water on you. It's more on this left side. You got to give it in first. Put your head back. I don't want it to burn down.
Honestly, with the way you would think he was literally being burned alive with the way this man is screaming. My goodness.
Get your head back. Hold your breath, I'm on water. Hold your breath. It's burning my butt. It's asshole. It's burning my butt. Here, stand up. It's fucking hot, man. Stand up. Hold on. Stand up. Oh, God damn it. Stand up. Oh, my God. Oh, shit. Fucking burns everywhere. Everywhere fucking burns. We don't have to go through this another time.
I think he said his butt's burning too, which it probably is. This looks like this is in the middle of May. Yeah, this is May 25th in Arkansas on the asphalt. Yeah, it's probably going to burn your butt if you're wearing shorts. So he's probably not wrong there.
My knee's hurting, man. Ouch. My left knee's fucking killing me, man.
Why are you limping? So okay, the limping is a little bit much. All right, settle down.
I got him coming. I got him around. Hey.
My knee's fucking killing me.
Yeah, go on.
Oh, God damn it.
And off he goes to jail after EMS treated his hurt feelings, of course. Yes, there is another 50 minutes or so to this video over on Natural State Transparency, so click the link in the description to carry on watching. Right, thanks for watching, guys. If you enjoyed this video, then please leave me a like, share the video, and subscribe to the channel. Thank you also to my...
Wait, so who was he talking to? Wait, who was he talking to? I guess I completely missed that. He called the state House of Representatives. Naturally. Oh, it's on the longer version. Gotcha. Great. That's fantastic. All right, I'm gonna. I guess I'll stop here. But holy hell, the screen, the lungs on that man were something else. But I'm gonna stop here. God, as you guys can see, this is an irritant. Hopefully, I'll just be able to get something on Amazon and get them tomorrow. Ow! Just transfer some money. What little funds I have left. Anyway, moving on. All right, I'll take you care, guys. So thank you for watching. I'll probably not be streaming tonight. Plan on going out, but hey, I was able to have a day off and hang out with you guys. All right. I'll probably try to stream tomorrow. With some gaming. Oh yeah, speaking of which, I'm probably gonna get these are Audio Technicas. I've had these since 2017, so they gave me a solid 6 years. So I'm gonna get the wireless version of these. So stick to what I know. These are pretty good. So and they aren't that expensive either. So with the Amazon points, they shouldn't be that too shouldn't be too bad at all. All right, guys, thanks a lot for watching. Hope you guys have a good rest of your day, and yeah, have a good one. Later.
My bitch a chew